Just so we know what's happening, there are notations as to each of the entries, but some of them say it's A or B, and that way we'll have a sense of what's happening right now. Just so we know what's happening, there are notations. So we are now live there. Just seeing who all is here. So who do we have on the call where it says Galaxy A10e? You're on mute right now. There you go.
We're the Calhoun family of Antonio Slaton.
Okay, got it. All right, I recognize everyone else. So here's how I understand the calendar. We've got Darnell Presley going first. Is that a plea, Mr. Franklin?
Oh, hey, excuse me, Judge.
Yes.
We got position number 3 going first.
Okay, we're going in whatever order the sheriff's folks tell me. Let me just call the calendar so I can figure out what we're doing with each, and then we will certainly go in the order that you all request. So it sounds like Mr. Slaton first, which is great because we've got supporters of his on the phone. But let me just see what we're doing. So Mr. Franklin, is Mr. Presley a plea?
Yes, it's a non-negotiated plea.
Non-negotiated plea. All right. And then Raymond Strozier.
Negotiated plea.
And then Ms. Render, what are we doing with your client today? Just bond hearing?
That would be a bond hearing, Your Honor. I would also like to speak to the ADA if possible. Okay.
Ms. Hall, are you handling, is it pronounced Slaton or Slatian, Mr. Render?
It's Slaton, Your Honor. I believe there's a mistake in the system. It's Slaton.
Okay, no extra E. All right. Ms. Hall, is this your case?
No, Your Honor. Deputy Convery, she's on the line. She's taking over this case.
I see, Ms. Convery. Hello, Ms. Convery.
Hey, Judge.
All right. So what we'll do is have the bond hearing, and then Mr. Render, you and Ms. Convery can connect afterwards, or I don't think I control this call. I could put you guys in a conference room where you could talk, but it's probably just, it's just easier to speak one-on-one when we're done with the bond hearing.
I'll just get a contact information after the hearing.
Great, sounds like a plan. And then position 4, Ms. Foster, Mr. Melnick. You're on mute.
I am sorry about that, Judge. I had switched my screen there for a second. Yeah, that's a negotiated plea, Your Honor.
Great. Position 5, is it Gary or Carrie Johnson?
It's Gary Johnson, Your Honor.
Yep.
And that will be a negotiated plea.
All right. This calendar is shaping up. And then I guess that's the same. It's just listed twice. All right. So Gary Johnson, that's just one case.
Yes, Your Honor, one case.
Okay, great. So back to jail. You all would like us to do position 3 first?
Yes, sir.
Okay, will do. Let me see what I've got. Just getting the case up on the screen. Looks like we've got some co-defendants here. Okay. Mr. Forte, are you ready? Okay, well, I'll call this case. It's indictment 20 SC 175651, State versus Antonio Slaton. Mr. Slaton, can you raise your hand so I make sure you're on the screen? There he is. Good morning, Mr. Slaton. Can you hear me?
Yes, sir.
Great, and I can hear you just fine. Mr. Slaton, your attorney, Mr. Render, is on this call as well. You should be able to see, at least on my screen, he's right next to you on the screen. Can you see Mr. Render?
Sir.
Great. Mr. Render has filed a motion for bond on your behalf. And we are going to talk about that today, about whether you should get a bond, and if so, what that bond is going to look like. Ms. Convery is the prosecutor handling your case. She's on this call as well. Mr. Slaton, before we get started, and I'll start by hearing from your lawyer, I need to make sure that you are waiving on the record 2 rights that you have. One of those rights is to be here in court rather than there at 6 South. Do you waive your right to be here in court? Okay, and the other right that you have that you're waiving partially by proceeding in this way is to have Mr. Render by your side so that you two could confer readily during the course of the bond hearing. Do you waive your right to have Mr. Render sitting next to you while we do this hearing? We can accommodate that a little bit, and by that I mean if during the course of this hearing you need to speak with Mr. Render, I think I can get you and Mr. Render into a private conference room. It's a virtual conference room. You won't move anywhere, but you and Mr. Render would be moved into that conference room where whatever you two say is just between the two of you. I can't hear it. The prosecutor can't hear it. No one else can hear it. So if something comes up where it's important for you to ask Mr. Render a question or share something with him, let me know, and I'll see if I can get you guys into that private conference room, okay?
Yes, sir.
All right, with that, we'll go forward. So Mr. Render, why don't you tell me why you think Mr. Slaton should get a bond and what the contours of that bond would be?
Yes, Your Honor. I would like to let you know that Mr. Slaton was 16 at the time that this incident happened. He is now 17. At the onset of this charge, he did spend 3 weeks in YDC. From that time, he was transferred to Rice Street. So he has been at Rice Street since February of this time without a bond. In regards to the allegations, Your Honor, Mr. Slaton was at the location. He was unarmed. From the discovery that I received, he did not have a weapon. He was apprehended at the location, as well as the other co-defendants. Again, this is his first offense. He has no record from my understanding, Your Honor. And going through the Ayala factors, Your Honor, I don't see that he poses a significant risk of fleeing, Your Honor. We do have his parents on the call, Your Honor. He is a minor, so he would not be able to travel presumably without their guidance and presumably without their say-so, Your Honor. He also poses no significant threat to the community or persons to the community. I do believe that he does have a strong foundation at home, Your Honor. I do believe that this incident has heightened his parents' senses as to what's going on. I do believe that they will step up and help him in this next transition, Your Honor. Again, he has not committed any crimes at this point, and the individuals he did commit this crime with, they were hardened criminals and all 30 above, Your Honor. Would say this as a crime of influence, partially. One and only occurrence, again, Your Honor. Position 3 was no significant risk of committing any felonies pending trial, Your Honor. Again, I will state that he has no other felonies. He is 17, Your Honor. First offense. If I know his history isn't indicative because he is young, but moving forward, I can be reassured through speaking with Mr. Slaton and his family that he will not commit another felony pending trial. And he poses no risk of intimidating witnesses, Your Honor. If he is given a bond, Your Honor, I would ask if it would be a stay-at-home order, if the court is inclined. This was a jewelry store in Buckhead. Mr. Slaton does live at 3087 Washington Road, apartment 3, East Point, Georgia, 30344. Again, Your Honor, he is a high school kid. He went to Peak Academy, or is going to Peak Academy. He's a junior at Peak Academy. He's an A and B student. He indicated to me that he's had 1 or 2 C's. He was in a leadership role in the after-school program. He would be a senior if he were to advance, Your Honor. And I would like to speak about bond as well, because his family is on call. They would like to speak to the fact that they would be taking care of him, that he would be at the house at 3087 Washington Road, Apartment 3. They can speak to the fact that he has not committed any crimes of this nature before, that he is in school. Again, he was 16 at the time of the crime, and now he is 17, Your Honor. So we're asking for a reasonable bond in the amount that the family can make. And Your Honor, I believe around this time, that would be around a $15,000 bond. As again, financials would be difficult at this time, especially during the coronavirus, Your Honor. A lot of difficulties have plagued the family. And again, they are on here willing to attest to Mr. Slaton and the fact that he will abide by the all factors, and that the home would be a place where he would be looked at and taken care of, Your Honor.
Okay, give me 1 second, and I have a couple questions for you, and then I'm happy to hear from Mr. Slaton's family.
Yes, Your Honor.
They must be mad I gave him another one.
Sorry about that. Had another judge come in here with an issue. All right, so why don't we start with the questions that I had, Mr. Render. So your client is now 17, which is why he's at Rice Street. He was 16 when the incident occurred. Was he living at home on Washington Road at the time of the incident?
Yes, Your Honor.
Okay. And you mentioned that he was a student at Peak Academy. Was he actively enrolled in Peak Academy at the time of the incident?
Yes, Your Honor.
Okay. And he would be a rising senior if Peak Academy opened its doors in late August or whenever school might start, if it was going to have students there, he'd be a senior at Peak.
Yeah, presuming that he would be transferred up, Your Honor, because this happened in January. He was a junior, so.
Okay, so he may have some makeup that he'd need to do.
Correct.
Okay.
And that would be one of the reasons why we would try to get him out this summer, Your Honor, so that he could probably do some of that makeup work and then transition to be a senior next year.
Okay, and your understanding is that the family might be able to make a bond of $15,000, and you are understanding that house arrest, other than maybe to go to school, although school right now would be virtual anyway, so he could be at home, that could be a condition of the bond.
Yes, Your Honor.
Okay. Is there anything specifically you would like Mr. Slaton's mother or father to add, or just for me to note that they are present, one, in his life, but two, here on the call?
I would ask them if they wanted to add anything, Your Honor.
Okay.
Is there anything you guys would like to add in Mr. Slaton's behalf?
Well, no, but I just want to say that Antonio, he did stray away on the day of that incident that occurred. He's really, really a good child. He really is. And this is a major eye-opening for him. And of course, the family as well. And we're going to do everything in our power to make sure that Antonio really obey by all of the rules and really, really understand the serious of the situation that occurred on hand. And I just pray for a great outcome.
Could I have your name, ma'am? It will help us make the record. The court reporter is taking down what you're saying, but it would be helpful if I could get your name.
Yes, my name is Trika Calhoun.
Ms. Calhoun?
Yes, sir.
Calhoun?
Yes, sir.
Okay. And does Mr. Slaton have any brothers or sisters who would be living at the Washington Road address with him?
Well, no, sir, not at the moment. All of his sisters, his siblings are adults and they're out on their own right now.
So he would be living there with you and the gentleman on the phone?
Yes, his father.
His father. Okay, great. I didn't want to ascribe anything, but so Mr. Slaton would be there with the two of you. Okay. And ma'am, do you know Antoine Robinson?
No, sir.
And how about Antonio Collier?
No, sir.
Okay. All right. Thank you. I think what I'll do now is hear from Ms. Convery, and then Mr. Render, I'll get the final word from you as the one who's petitioning for bond. Okay.
Yes, ma'am.
Good morning, Ms. Convery.
Good morning again, Judge. I'll just I want to give the court a little bit of background. I'll keep it very brief as far as the facts are concerned. But this is an armed robbery incident that happened at Alex the Jeweler, actually in Sandy Springs, not Buckhead, on January the 25th of this year. Essentially, there are multiple employees and customers inside the location. It's really right in the middle of the day. Silver car pulls up, and eventually 3 people make entry into the store. There's sort of a co-defendant first who sort of scopes out the scene. He can be seen, and this is all captured on video surveillance. Gloves, masks, makes entry into the location. Mr. Slaton is the second individual into the location. 2 of the individuals are armed at that point, tells everyone to basically get on the ground. You know what this is. Mr. Slaton's role has a large duffel bag, pulls out a hammer, and actually shatters several of the jewelry cases and begins taking items out of the cases and loading them into the duffel bag he has with them. The third co-conspirator, co-defendant, sort of stands back at the door with a gun, while the other 2, who are the younger 2 defendants on the indictment, do the large amount of robbing inside the store. As they are leaving the location, they're actually confronted by one of the employees who's on his way back from buying lunch, and he's able to somehow get into a physical exchange with Mr. Slaton. The other 2 get away in that silver car that first pulls up. Because of the response time from Sandy Springs, the oldest male on the indictment and the other individual that got away in that silver car, they're also apprehended a short distance away, one in a dumpster and one in like a wood line as he's fleeing the police. Mr. Slaton's actually apprehended by the employees of the store, and they're kind of holding him there until Sandy Springs arrives. The significance of that, and the reason I wanted to bring that to the court's attention, is because during that little detention period, while they have him there, obviously officers are able to recover a lot of the jewelry from the store in that duffel bag, but he is making threats to those individuals. Mr. Slaton is, during that detention period, telling them that he's the blood, that he will be back, that he'll be back to hurt them, that they're going to pay for this because he's a blood. I want the court to know that, because I think it's a responsibility of mine to let the court know that the people involved in this case are absolutely terrified about that. It's something that they've mentioned to me multiple times, and there's 2 really brief impact statements that I'll ask the court to consider when it's appropriate. But he's subsequently taken into custody. At the time of this incident on January 25th, according to my records, he had only been at the Peak Academy from the 13th of January on. And again, that's the records I have available from juvenile court. So January 13th, 2022, the time of this incident. He also had a pending open DeKalb County juvenile incident. It's case number 19J 02411. And all I can tell from the records available to me at this point is it's an assault. That's how they code it. I don't know much else about the circumstances of that, whether that would be a misdemeanor assault or if that's DeKalb's. It just says assault. So when officers took him into custody on the 25th, they actually were able to confirm he had a flag warrant, and he was immediately transported for the hold to YDC as well. He also has a distribution of controlled substances adjudication. That case was closed officially on March the 5th of 2020, and it looks like there's kind of some initiating action in early January of 2020, so immediately prior to the incident on this indictment as well. And there's some other juvenile things on the history, but those look like the only cases there on the history. Additionally, I do want to bring it to the court's attention that there was a recent jail incident involving Mr. Slaton on May 23rd of this year in Fulton County in Rice Street custody. Central allegations are that he attacked another inmate while in the jail. They were able to move that individual, but I again bring it to the court's attention. There was a follow-up amended report from the jail where essentially this individual makes it known to jailers that he's been assaulted. He's actually just discovered injured. He doesn't even go to the jailers. They just discover that he's got an injury. He names Mr. Slaton as the person responsible for the injuries, but doesn't want to, write a statement or make it any bigger than that. After it's found out, though, that he's interviewed, he's threatened with shanks essentially inside the jail. And he identifies Mr. Slaton and other individuals on that floor as the people responsible for that. And that was on the 23rd, and looks like the jail sort of closes that situation up on the 26th of May of this year. So those are sort of some of the reasons that I'm asking the court to maintain Mr. Slaton in a no bond status. I don't like to argue factors to the court that I don't think are seriously implicated. My primary concern is that he is a risk to intimidate witnesses. The victims in this case are terrified about him having bond at this point because, again, about those direct threats to come back and return or have someone from his criminal street gang organization return. I think he's a risk and danger to the community based on this reoffense and risk to reoffend. I'm arguing that because we've got something open and pending while this is happening, all in the same month. So, unfortunately, it's all right there in a concentrated period of time. And I think he's a risk for bond to reoffend, a danger to the community. Unfortunately, the facts and circumstances of this case are pretty egregious. And of course, Mr. Slaton is caught on scene. The entire incident is captured on video, and the victims in this case are, their accounts of what happened are consistent with that. So obviously it's a pretty strong case for the state. So it's just for whatever it's worth to the court, factoring in him being a risk for flight. I understand he's got family here present, but my primary concern is him being a risk to reoffend and a danger to the community. I've got 2 impact statements. They're very brief for the court to consider whenever you think it's appropriate.
Sure. I think now would be the time. I have one question. So Mr. Slaton and Mr. Robinson are the younger 2 of the 3, and then
That's
Mr.
right.
Collier would be, may have been Mr. Robinson was a juvenile at the time, but Mr. Collier is the older of the 3.
That's right.
And your understanding of the case is that Collier and Robinson had the weapons. Slaton had the hammer, arguably a weapon, but it was used to shatter glass. And it was Slaton who was grabbing the jewelry when some employee returned to the store and was able to detain Mr. Slaton until law enforcement got there.
Yeah, and there's I think at least one of the employees is injured during that exchange. He's got a pretty bad injury on his hand. But yeah, they're able to, the other 2 kind of get past and are able to get into the car, and Mr. Slaton gets caught up with the employees as they're coming back in.
Okay. I see Ms. Rolak on the phone as well. Is she providing the impact statement?
That's right, yeah.
Great. Good morning, Ms. Rolak.
Uh-oh.
Judgy, good morning. My name is Esfira Vera, V-E-R-A, Abramova, A-B-R-A-M-O-V-A. I am one of the victims of a robbery that occurred on January 25th, 2020 at Alexa Jeweler. I and 2 other victims were held at gunpoint at the store while being robbed by Antoine Robinson, Antonia Collier, and Antonia Slaton. That day was the worst day of my life that I will never forget. I live with fear and anxiety because of this incident. Antonia Slaton was caught by my husband, Arkady Alex Yakubova, Yakubova, as he was running out of the store with the stolen merchandise in his possession. Alex subdued Antonia Slaton until Sandy Springs police got there. I was present at the time right outside of our store. While Alex was holding Antonia Slaton down along with Robert Gales, who is another victim held at gunpoint at the store along with me, Antonia Slaton was threatening to come back to retaliate, and he also stated that he is Bloods and that Bloods don't give up each other. We have a teenage daughter, and we fear for our family's safety. These three guys should face the consequences for committing a crime that will affect our lives for many years. Please deny Antonia Slaton's bond, as he is a danger to society. Sincerely, Esvira Abramova. 1 second to pull up the other one, Judge.
Okay.
And this is from Robert Gale. Good morning, Judge Robert McBurney. My name is Robert Gale, a resident and local business owner in the city of Sandy Springs for the last 14 years. That beautiful afternoon on the 25th of January changed my life forever. I have never felt so helpless in my life. Just the thought of that day brings back so much emotions that I can't explain. I cried like an infant when the paramedic was attending to my left ring finger. I still have physical issues with my hand from the altercation with Antonia Slaton on the sidewalk. My emotional state has been altered sufficiently when I am around crowds. Just a reminder of being in a tight corner with three robbers with guns, hammers, mace, not knowing what next gives me the chills. I would never want anyone to have to endure that horrible experience. Having a gun put to your head is never a good feeling. Not having an answer for my two children was my biggest fear. These guys don't ever need to be set free. They are a menace to society and with no remorse for anyone or anything. Antonia Slaton stated he was gang-related, Bloods, and will come back to do more harm. I'm sure you have a lot of cases to handle on a daily basis. With all your power, please do what is best for society. Neither one of these defendants deserve a bond. Thank you.
Thank you, Ms. Rolak.
Okay.
So, Ms. Convery, it sounds like all three defendants are in custody. And what is the state's posture now? Has discovery been provided? Is there a continuing investigation? Because I'm about to ask Mr. Render what he thinks the status of discovery is. What do you think?
So Ms. Hall brought this case to my attention, I think back in March. I took the case over and just because she had already provided a significant amount of discovery. Since then, I've supplemented that and got I don't want to say more complete because Ms. Hall did a complete investigation as well, but I supplemented discovery. I believe the discovery to be complete. I don't see, and I was double checking, honestly, I didn't see your typical case management in here. So, and I know there has been some change in attorneys, certainly at least as it pertains to Mr. Slaton. So if he doesn't have that, the complete package exists now. We're ready to go forward. If we get a new grand jury, I may do a couple things to the indictment just to clean up some issues, but we're ready. Case is complete. I've met with the detective and spoken with these victims. So I don't see any reason for delay as far as my posture is concerned.
Okay, don't hold your breath on that grand jury.
Yeah.
Mr. Render, I know you are new to the case, that Mr. Shepard had it for a while and has
Yes, Your
rolled
Honor.
off. Do you feel like you've got all the discovery
No.
that's out there?
No, Your Honor. Those impact statements are brand new to me, Your Honor. From the discovery I have. I don't believe that was included in there. I know the ADA said there was some supplements. So I do believe that there's some extra things in there that I would like to be privy to.
Sure.
And just to have another bite at the apple, Your Honor. The other two individuals were older than Mr. Slaton, and they were armed, that he was unarmed. I know the impact statements indicate, you know, the guns and things of that nature, but Mr. Slaton did not have a gun. And I understand that they were scared and things of that nature, but Mr. Slaton was also 16 at the time. We understand that at 16, we do make some mistakes. Regardless of his age, Your Honor, we know that the criminality of his acts was wrong. But again, he was a 16-year-old without a gun. Again, I was not privy to those impact statements. I know he was apprehended on scene. And as far as the open juvenile case, from my understanding, that case was closed. The open YDC case, from my understanding, that case was closed, and I can provide some documentation as far as the father has indicated that he does have adjudication paperwork of that hearing date. As far as the jail incident, Your Honor, I have been visiting Mr. Slaton on a number of occasions. And as far as the jail goes, I have no idea of any incident at the jail. Mr. Slaton is one of the youngest members at Rice Street Jail. And to intimate that these individuals who are hardened criminals who have been there multiple times and are much older than him are scared of Mr. Slaton, I believe that's jumping the gun, Your Honor. I believe there should be an investigation into that. I don't believe that should be a part of a reason for him to be denied bond when we have no idea what's going on at the jail, Your Honor. I have been given no information, and there's been no charge, as I've seen, from Mr. Slaton at the jail. So again, I don't know where that's coming from. I've been to the jail multiple times, at least once or twice, once a week at least, or video chats, and I have had no I had no information regarding that. I'm not saying that it's not true, Your Honor. I'm just saying that I had no information of that. And again, that's a situation at the jail, which of course can be attenuated. Just to close, Your Honor, again, I understand the impact of those victims, and if there's a stay away ankle monitor, stay at home order, I believe that would remedy the situation as far as the victims being scared of Mr. Slaton. But I would just like to input in this conversation that this was a 16-year-old at the time, and Mr. Slaton is not 17. He's been incarcerated for 6 months without a bond. I understand how the ADA feels about the case, and I completely understand how the victims feel. But I just want to put out there that this is a young man who, by being in Rice Street and not being able to adapt on the outside, is becoming a hardened criminal. Those things that in the jail that can happen, if continued, won't help Mr. Slaton at all. I believe rehabilitation at this point would be better because he hasn't shown a track record of continued crimes from what I've seen, Your Honor. So again, I would like to put that on the record, and we're just praying for a bond.
Okay. Ms. Crawford, good morning.
Good morning, Judge.
I just want to confirm that Mr. Slaton doesn't have any record from your check. He shouldn't, but I need to do my due diligence here.
That's correct. He has no record found, just the DeKalb County hold.
Okay. And what is the DeKalb County hold for, if you can tell?
It doesn't tell me, it just notifies, has a notification of a hold for DeKalb.
Okay. All right. Thank you.
You're welcome.
So, Mr. Slaton, you are in a complicated spot. You've got family that cares a whole lot about you. They've taken time out of their day to be on this call, and they are offering up it sounds like a safe environment for you. What I'm stuck with and struck by is that environment was there for you back in January. And instead of taking advantage of that and all the good things Peak Academy had to offer, it sounds like, and you, of course, are innocent of all these charges unless and until you admit to them or the state proves them. But it does sound like this can be a pretty complicated case to defend, even in Mr. Render's very capable hands. That you got mixed up in something, admittedly as a 16-year-old, but it doesn't sound like you were real surprised about what was going on at the jewelry store. or that you were simply just standing by watching as these bigger guys did these things. So I appreciate Mr. Render's observation that there's no allegation that you had a deadly weapon. That doesn't make less serious what you got wrapped up in. And it didn't decrease the risk that someone, whether it's someone, the group of guys you were with, or the folks who were minding their own business at the store, could have been real seriously injured because two guns were brought to the scene. I do find that there is not a set of conditions I could impose that would, one, keep you out of trouble, and two, keep potential witnesses or folks who were involved in this case out of harm's way. I think it's good to hear that the state believes that discovery is done. It'll be important for Mr. Render to speak with Ms. Convery right after this session. And I'll tell you this, Mr. Render, while I am denying bond at this point, if it comes to pass that you are having any difficulty getting the rest of discovery from the state, I don't think that will happen, but if it does, you need to let Ms. Nelson, my case manager, know that, and we will reconvene. I don't mean to extend your client's time at Rice Street any more than absolutely necessary. I agree with you 100% that life for a 17-year-old at Rice Street is an upside down, crazy world where there are very few positive influences.
Right.
There aren't zero positive influences, though. I also meet young men who, while they're there, instead of allegedly, and I'm with you, it's allegedly getting in fights, they are trying to get their GED or they're plugged into other programs. And maybe that's what Mr. Slaton's trying to do with his time while he's there. But this is a matter that I think will be resolved while Mr. Slaton is in custody. I think that's the safest route. And that is not to diminish in any way Ms. Calhoun's offer and Mr. Slaton's father's offer to provide that household for Mr. Slaton. I'll just repeat my observation that their care for him and their willingness to support him was there before. And as Ms. Calhoun put it, it sounds like Mr. Slaton got pulled away from that, maybe by the bad influences of these other gentlemen named in the indictment. But it's not something that I can step back from. And when you couple that with the two juvenile matters, whether they're adjudicated or not, it makes a more complete story than simply to say Mr. Slaton's never been in trouble before. As an adult, true statement. As a 16-year-old young man, it sounds like the waters were pretty choppy for him before he showed up at Alex the jeweler on January 25th. So at this time, I'm going to deny bond. I will ask you, Ms. Convery, to let Mr. Render know how you two can communicate, and if you could connect today, just to make sure whatever Mr. Render thinks he might be missing beyond the victim impact statements. I'm not as worried about those, but if there are pieces of discovery, an interview, video, something like that, we need to make sure Mr. Render got all that from Mr. Shepard or from Ms. Hall or from you, because this is a case that I'll want to have move pretty quickly so we can get closure for Mr. Slaton, a young man at Rice Street. And I believe Mr. Robinson isn't a whole lot older and is going to probably want the same type of closure. Not to say the third gentleman doesn't either. It just, everyone seems to be describing him as like this 80-year-old guy. And so it's okay that he's in jail.
That much.
And it's not. I mean, we need to get closure for all three, but we've got Mr. Slaton here and now.
I
Mr.
understand.
Renner, any questions right now?
No, nothing further, Your Honor. I'll just reach out to ADA Ms. Convery.
Sounds like a plan. Thank you.
Thank you, Judge.
Thank you.
All right, who are we going to do next? Jail?
Position number 5.
Gary Johnson, Ms. Patel, and Ms. Hall. Are you Mr. Johnson?
Yes, sir.
How you doing, Mr. Johnson? Great. Ms. Patel, you ready to get on the record?
Yes, Your Honor.
Ms. Hall?
I'm ready, Your Honor.
Okay. Position 5 on our calendar is indictment 20 SC 174847. I have the case file, which means I'll have the original indictment or accusation. It is State versus Gary Johnson. Ms. Hall is representing the state. Ms. Patel represents Mr. Johnson. Mr. Johnson, my understanding is that you are prepared to enter a negotiated plea in your case. Is that right?
Sure.
So there are 2 waivers we need to talk about. One, Mr. Johnson, is the fact that by appearing remotely as you are waiving your right to be here in court, open court, where the public could be physically present for your plea. Do you understand that you're waiving that right?
Yes, sir.
And you're comfortable doing that?
Yes, sir.
Okay. The public is actually able to observe what's going on. This hearing is being live streamed. So if you have friends or family members who are interested or concerned, they are able to watch and hear what's going on. The second thing you're waiving, and it's only a partial waiver in this respect, Mr. Johnson, is the right to have your attorney, Ms. Patel, by your side. She, of course, is present remotely as well. She's on the screen there. But I want to let you know that if at any point during these proceedings you need to speak privately with Ms. Patel, I think we can get you into a virtual conference room where it's just the 2 of you speaking. I can't hear what's going on, and the prosecutor will not be able to hear what's going on. Do you understand that?
Yes, sir.
Are you willing to proceed with Ms. Patel being only virtually present for your plea?
Yes, sir.
Okay. Then in just a moment, Ms. Hall is going to put you under oath. Once you are under oath, it's important that you answer all of her questions and mine truthfully and completely. It is also important that you let me know, or Ms. Patel, if you have any questions of your own, because at the end of this conversation that we're about to have, I need to be comfortable that you understood everything that was going on. Will you let me know if there's something you don't understand or that you can't hear because of the way the system is working?
Yes, sir.
Great. Just raise your hand or wave or do something if we need to pause to get a question from you. All right, Ms. Hall, when you're ready.
Thank you, Your Honor. And Your Honor, for the record, this is a reduction from theft by shoplifting to disorderly conduct.
Okay, thank you.
You're welcome. Mr. Johnson, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. You may lower your hand. Please state your true, correct, and legal name.
Gary Ward Johnson III.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
43. GED.
Are you
say
able-
23?
43.
43. Okay, you look young for 43.
Thank
When
you.
did you get your GED?
97.
97? Okay.
Oh, Mr. Johnson, are you able to read, write, and understand the English language?
Ma'am.
Do you understand that you've been charged with theft by shoplifting, being reduced to disorderly conduct?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Patel, about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you?
Mr. Johnson, are you able to you may be stuck at a table there. It's real hard to hear you. And I worry that our court reporter, if you have to say something more than yes or no, and there may be some open-ended questions, it'll be hard to hear you. So if you don't mind just kind of belting it out, okay?
I got you.
Yep, that was much better. Thank you. Use those 43-year-old lungs.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Waived for the purposes of this plea only.
Mr. Johnson, have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
Did your attorney advise you of the minimum and maximum sentence to the charge that you're pleading to?
Ma'am.
Has your attorney advised you of the minimum and maximum sentence of the 12 months to serve for the charge that you're pleading to?
Did you say that again?
Yes.
Okay.
Do you understand, Mr. Johnson, that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months to serve 165 days, commuted to time served upon entry and completion of We Are a Living Proof program? But the court does not have to accept that recommendation. The court can sentence you to the maximum on this charge, which is the 12 months to serve. Do you understand?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
How do you plead to the single charge of disorderly conduct, OCGA 1611-39B, and indictment number 20 SC 174847?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Mr. Johnson. Your Honor, had this case proceeded to trial, the state would have proven that on, excuse me, on December the 24th, 2019, at 4455 Fulton Industrial Boulevard, that's a Texaco gas station, officers were flagged down by the manager of that store, who stated that someone had broken into their location and stolen 5 boxes of candy and left the store. I'm sorry, Your Honor, and left the store. That manager showed the officer security footage that showed the defendant stealing the candy. They located the defendant at 440 Fulton Industrial Boulevard and took him into custody. The defendant was transported to Fulton County Jail and charged with theft by receiving stolen property. Your Honor, the defendant does have 14 prior felony convictions. Most of those charges are drug-related charges. I have been working with the defense counsel on this case. There is no restitution. The boxes there is no restitution being requested. But after talking with defense attorney and my supervisor, we felt that the best way to resolve this case is to get Mr. Johnson into a program. He has currently served 65 days in custody. So that is all from the state, Your Honor.
What would the 3 most recent convictions, felony convictions, be for? Well, I may be able to find that just by looking at the repeat offender filing. So let me ask this, well, because I'm more interested in this next question. And Ms. Patel will chime in when it's her turn. Why did we not consider Mr. Johnson for drug court if what is behind stealing candy in bulk quantities from a Texaco station, if what's behind that is a drug addiction? And I'm asking because We Are Living Proof may be a great program, but there's no program that's going to help Mr. Johnson sufficiently in the 6 months that I could require him to be in a program, since we're dealing with a misdemeanor rather than a felony. And clearly getting another felony isn't going to change life for Mr. Johnson a whole lot. So I'm not trying to upset the apple cart. I just am trying to work through why folks wouldn't have said, well, let's try drug court, or I don't mean to pretend that's a panacea, something else that is denominated in many months rather than the half a year that would be left on this sentence.
Yes, Your Honor. So actually, Ms. Patel can probably go into more details. The state's first option was drug court in considering the reduction in this case. And Ms. Patel went ahead and jumped on that, but I believe the issue was the drug court did not accept him. But I think she can explain more. And so then we went to a different program, just not throwing him on probation or trying to just create more prison time. So that's my understanding, that he was not accepted to drug court.
Okay, and I'll hear more about that in a second. Before I pivot to Ms. Patel, Ms. Crawford, I'm looking at the criminal history as tallied up by the assistant DA in the non-complex division, and it lists the most recent conviction for Mr. Johnson as a 2014 Fulton robbery. Is there something more recent than that?
He's currently on probation for that 2014 case, Judge.
Okay.
But the other charges that I see, the latest one was I think a 2017 case out of DeKalb County. The number is 17 CR 175-7, and that's going to be 1 count of possession of drugs. The second count is a misdemeanor, just as other states law. So
is that case closed?
Yes, that case is closed. So
okay.
the only
How much?
case,
I'm sorry.
How much time on the 14 case?
Yeah, and that's the one that ends in 469.
Yes, sir. 14 SC 127469. He has 1 year, 3 months, and 1 day remaining.
Okay, and that's the only open case that you see.
That's correct.
Okay. Well, Ms. Patel, we may want to resolve that one too, just so that it doesn't come back and grab Mr. Johnson. But why don't you start in whatever way you want, Ms. Patel, but I would like to understand a little bit about the misdemeanor resolution and We Are Living Proof.
I think the defendant is trying to get somebody's attention.
Oh, okay. I'm sorry. Hey, Mr. Johnson, I had been looking at a different thing on the screen. What's going on, Mr. Johnson?
That she's speaking on has been resolved. I think that was in February.
Okay, well, I'll look in the system. We're not going to do that one twice. And it was resolved, Mr. Johnson, in connection with this. I'm still not sure why this is charged as shoplifting, but this case was the basis for you getting in front of a judge about your old probation?
Probation, right, exactly.
Okay, well, I'll look it up right now. So I've got a order of revocation signed by Judge Cottle on January 17th. And the basis for it were new convictions in 2017, not this case. So I don't think that's accurate to say that these charges were the basis of a revocation. It says new convictions from February 2017, May 2017, and a failure to report. But we'll work through that. That's not going to undo things here. Ms. Patel, why don't you tell me what you think is going on here?
Thank you, Your Honor. Drug court did not, he was interviewed by drug court. They didn't accept him. And I think it was that the basis being that they didn't think he was suitable because of his desire to do an inpatient treatment program, and the fact that they didn't think that he would successfully blend into their program structure. And so we looked at two options for him. We Are Living Proof, which is located in Duluth, and Georgia Works. Georgia Works has not started taking new people in their program again. However, Living Proof is. Living Proof is a spiritual-based recovery program. It is inpatient. The individuals are required to stay and reside in their location in Duluth. They are required to have NA and an AA counselor with them. They have campus scheduled events. They are also put into a work recovery phase towards the end of the program, which is roughly a year, in which they attempt to help these individuals get full-time legitimate employment. There are some fees associated with it. However, the way that they are able to pay the fees are by participating in essentially working to maintain the premises. They all have chores. And so the idea of cook their own food, do their own laundry, clean their personal areas, as a means to become self-supporting and clean. And we also thought that perhaps it would be best to have Mr. Johnson away from the city of Atlanta while he's in this program. As Georgia Works, I don't think, while it does have some structure, I think that Mr. Johnson is proof that he needs a little bit more than that, and that he needs something that is similar to Better Way Ministries. It's not close to the city, and where he doesn't really have a place to go. He can't walk around downtown or do any of that stuff. And so part of the reason Mr. Johnson had been able to stay clean for a couple years, he got a job working for Coca-Cola. He has a spinal injury that he had to get surgery on, and because that required an extensive recovery time, Coca-Cola let him go, and that caused him to relapse. And so I feel that if Mr. Johnson is able to maintain gainful employment, that tends to help provide him stability that he needs to stay out of trouble. In this case, the store that he took the candy bars from is a store he regularly frequents. He knows the clerk. The clerk was even surprised that he just wandered in, took 5 boxes and walked right out like nothing was up. And so when the officer found him, he wasn't far from the location, and he had the candy bar boxes with him. As Madam Probation pointed out, he does have some felony probation left. And so I think that could potentially cure the court's concern about having some more time that he's under the care and supervision of probation. And I don't think that Mr. Johnson would have any objection to having the program be a condition of that probation revocation as well. But I am hopeful that this program will work for Mr. Johnson and will get him clean. he had a good job, and it just seems that now that his surgery is done with, hopefully he can maintain that job and not relapse.
Okay, that's helpful. And I'm disappointed that drug court didn't work out, but meaning he wasn't accepted, but at least that was explored. Mr. Johnson, it looks like from your criminal history that cocaine is the drug you struggle with the most. Is that accurate?
Yes, sir.
Okay, and how is your back now?
It's fine.
Okay, whatever surgery they did has fixed what the issue was? Great. Do you think you'd be able to get back to work, or did the doctor say it's fixed, but you should never lift anything heavier than a pencil again?
No, I'm good now.
Okay, all right. Do you know, Ms. Patel, I want to make sure we have a clean handoff, by which I mean, rather than simply saying get out of jail now and I hope you show up at We Are Living Proof, what is your vision for getting Mr. Johnson directly from Rice Street or the Marietta Annex to the program?
So, Your Honor, we are asking that a hold be placed on him. Right now, our office is sort of touch and go. Ms. Markowitz is working with the marshals or accountability court to provide transportation for our clients. That would be step number one, is to see if we can get the U.S. Marshals or accountability court to facilitate the transport. In the event they can't, Mr. Johnson has a mother that lives here that can provide transportation. The program is very specific about with COVID, they cannot, the person has to be transported without any stops along the way. So it's to minimize contact with anybody else. And so Mr. Franklin has had a lot of luck with getting his client transported through accountability court. And so the hope is that they will help us in this instance. If not, worst case scenario, we do have his mother as a backup, but I'm hoping that we don't have to resort to that means.
Sure, good. I was going to recommend accountability court as well. They have been remarkably generous with their transportation capabilities to help get people to programs that do a lot of what accountability court does, that are, for whatever reason, the programs that the clients are going to. So you will present to me, Ms. Patel, a transportation order that would say, please release, I may not say please, but release Mr. Johnson to X, whether it would be drug court personnel or worst case scenario, Mr. Johnson's mom, for purposes of transporting Mr. Johnson to, and it'll have the address for Duluth. I mean, you know how it'll look, but
correct.
I will wait on that. My sentence won't be reduced to time served such that Mr. Johnson gets out mistakenly today without a way to get to We Are Living Proof.
Correct. And so I've been waiting until after this to meet with Ms. Markowitz to arrange a date. Living Proof, fortunately, is fairly flexible, so I think it can be done within the next week in terms of when he's trained.
Okay, got it. And Mr. Johnson, where do you envision staying when you're done with We Are Living Proof? Or is that a little ways down the road and we're not going to worry about that?
So the way I was explaining to this, they supposed to help me with a place to stay afterwards anyway.
Okay, so part of what you'd be doing is looking for work that's sustainable and housing that is something you can do.
Exactly.
Got it. Okay. Have you had drug treatment of this intensity before, where you're actually residing at a place that's focused on recovery?
No.
Okay.
A long time ago.
What does that mean?
It was a while back.
But like 5 years ago, 10 years ago?
More like 10 years ago.
Okay. All right. Okay. Do you have any questions about anything we've talked about?
Are we going to get everything resolved to where I can go to the program?
So what I'm going to do is tell you what I think does that, and then your lawyer is going to say, you need to do it this way or that way. And so the goal is, yes, to have it resolved that as soon as Ms. Patel can line up transportation from where you are to We Are Living Proof, it'll happen. That won't be today, don't hold your breath, and it certainly won't be over the weekend, but hopefully early next week, we can make that happen. So I'm gonna do a little talking right now. First, Mr. Johnson, I find that there's a factual basis for your plea to disorderly conduct. I also find that your plea is knowing and voluntary. Knowing means that you've understood all the things we talked about, or if you didn't, you raised your hand and we worked through them. Is that a fair statement?
Yes, sir. Yes, sir.
Voluntary means no one's forcing you to enter this plea. It's something you're doing because after consulting with Ms. Patel, you've decided it's in your best interest to go forward with the misdemeanor plea. Do you agree with that?
Yes, sir.
All right. Well, I'm going to accept your plea to disorderly conduct. And what I'm going to do is sentence you to 12 months to serve 6 months. The 6 months will be reduced to time served upon your transport to and entry into the We Are Living Proof residential treatment program in Duluth. That builds in a 15-day window to figure out how to get you there. If I said 165 days, I think the jail might have to release you. And I'm not interested in keeping you there a minute longer than we need to, because there's help outside there waiting for you. I just want to be sure that we get you directly there.
Yes, sir.
That's how I'm going to structure the sentence. And then it will be, the balance of your sentence will be on probation. I will waive any reporting fees for probation, and I will make it a special condition of your probation that you remain involved with the We Are Living Proof program for the full 6 months. So
Yes,
if
sir.
you walk away after 1 month, or you get kicked out after 1 month, and I get wind of that, that would be a meaningful violation of your probation on this case, which is the 2020 case. But I'd also like to resolve the open case, your robbery from 2014. Ms. Patel, do you waive any due process notice rights that Mr. Johnson would have? I do think that this new conviction could subject him to revocation in that case. In looking at Judge Cottle's revocation order from January of this year, it makes no mention of an arrest from 2019 or anything like that.
Yes, Your Honor.
Okay. What I propose to do with the probation in 14 SC is revoke 1 day, and then reinstate the balance so that we've got 1 year and 3 months left. And it will now be a special condition of your probation in 14 SC 127469 that you enter into and complete the We Are Living Proof residential drug treatment program. And that just gives us more time to work with. It may be that the program for you, Mr. Johnson, ends up being 9 months or 10 months. I'll have no authority on this new case to keep you in the program after 6 months, because there's only 6 months of probation on your taking the candy bars case. But we've got 1 year and 3 months in the old robbery case. And I know that seems like an ancient case, but you got a long sentence, and we're going to use that long sentence as an incentive for you to stay in the We Are Living Proof program. I think the way I've described all that, it gets you out just as soon as we can get transportation from the jail to We Are Living Proof. Do you agree with that, Ms. Patel?
Yes, I think that until the order is done, they will keep him in custody because of the entry and completion of language.
Good. That's my goal. And then as soon as you have that transportation order ready, zap it to Ms. Nelson. She'll get it to me. I'll sign it. And Mr. Johnson, you have for many years been plagued by the addiction that you've got. And you know, It doesn't just go away. It's always lurking, and there can be triggers. It sounds like you had a couple good years with Coca-Cola. I'm hoping that time focused on recovery at We Are Living Proof may get you back in that productive way. Despite looking like you're 23, I now know you're 43. You got to be sick and tired of being in jail. That's young man stuff. You should be out there just earning a decent pay and staying out of harm's way, and ultimately taking care of your mom. We shouldn't have her driving you to We Are Living Proof. You should be taking care of her, okay?
Sir.
You got any questions about that?
No, sir.
Ms. Hall, I'm going to talk about signing the indictment in a minute, but beyond that, anything else?
Nothing further from the state, Your Honor.
All right. Mr. Johnson, I have in my hand the original indictment in your case. If you were here in court, you would sign it today saying, I plead guilty to the reduced charge of disorderly conduct, but you're there and I'm here. Do you authorize me to sign this indictment on your behalf?
Yes, sir.
Ms. Patel
Yes, Your Honor.
and Ms. Hall?
Yes, Your Honor.
Great. I will sign for all three of you. I'll indicate that the charge is reduced to disorderly conduct, and we will move this case along. I'll also sign a revocation order that Ms. Crawford will get my way later today or on Monday that adds to your probation in the 14 SC case that you need to complete the We Are Living Proof program. Ms. Patel, anything else for Mr. Johnson?
Nothing further.
Ms. Hall?
Nothing further, Your Honor.
All right,
Judge.
Mr. Johnson, let's make this work, okay?
Sure.
Judge, can you check your chat for me, please?
Yes. Oh, so what I'm going to do now, if Marietta Annex will keep you on, Mr. Johnson, I'm going to put you and Ms. Patel and Ms. Crawford in a private chat room so that Ms. Crawford can share with you the reporting information you need for your probation, okay?
Okay. Yes, sir.
All right, let me see if I can make this happen. If I can't, then we'll just do it here in front of everyone else. All right, Marietta Annex, Patel, Crawford. Ms. Crawford, you need to come back when you're done. And I don't remember if you have more cases, Ms. Patel, but if you do, we need you to come back as well, okay?
I do not, may I be excused after that?
Have a great weekend.
Well, I'll see you at 1.
Oh, all right, I'll see you at 1. Have a great morning.
Thank you.
All right.
Hello, Judge McBurney.
Hey, hold on one second. Ms. Crawford, you should get a little invitation to join the breakout room. She's frozen now. Hopefully she got there. Okay, let me get back to the main screen. Are we going to handle Mr. Melnick's case now?
Yes, sir.
Great. Let me get that in front of me. .602. All right. I don't have this file. It doesn't mean we can't move forward with it. So this is position 4. Are you Ms. Foster?
Yes.
Can you say something?
Yes, sir.
Great. Nodding is fine, but when you're answering questions, the court reporter is going to need to be able to take that down, and we're going to get on the record in just a moment. All right, Mr. Melnick, are you ready to go forward?
I am, Your Honor.
Great. Okay, position 4 on the record is indictment 18 SC 161602, State versus Takeshia Foster. Ms. Foster is represented by Mr. Melnick, who is on this virtual session, and the state is represented by Ms. Hall. And it's my understanding this is a negotiated plea. Ms. Foster, I need to ask you a couple questions before Ms. Hall puts you under oath and we go forward with the plea. The first is, are you willing to waive your right to be here in open court, here in courtroom 1D with me, and instead proceed remotely with you and your lawyer in separate locations?
Yes.
Okay. Second one is related. Are you willing to waive your right to have Mr. Melnick right there by your side so that if you had a question, you could just lean over and ask him and he could answer that question. Are you willing to waive that right?
Yes.
Okay. You should know, Ms. Foster, that if something comes up during this plea that prompts you to want to have a private conversation with Mr. Melnick, we can make that happen. You may have just seen it happen. I moved 3 people into a chat room, and that is a private, I cannot hear what's going on there. The prosecutor cannot hear what's going on there. Whoever's sitting in the room with you might hear about it, but you and Mr. Melnick would be able to speak privately. So if you need to do that, will you let me know?
Yes.
Great. All right, Ms. Hall will put you under oath. Once you're under oath, it's important that you answer her questions and mine truthfully and completely. And it is no less important that if you have a question about something that was said, because you don't understand it or you couldn't hear it, that you raise your hand and let us know that you've got a question, okay? Yes?
Okay, yes.
Great. All right, Ms. Hall.
Thank you, Your Honor. Ms. Foster, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. Please state your true, correct, and legal name.
Takesha Renee Foster.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 39 and I've had some college.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with theft of services, possession of a false identification document, and giving false information to a law enforcement officer?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney, Mr. Melnick, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, I have.
Do you need more time to discuss this case with your attorney?
No, I have discussed it with him.
Are you satisfied with his services?
Yes, I am.
Counsel, do you waive formal reading of the indictment?
We do. Thank you.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, we do.
And do you waive moving forward on a copy of the indictment if we can't get an original copy of it?
I'm fine with moving forward on a copy.
Thank you. Ms. Foster, have you been arrested on these charges?
Yes, I have.
The state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
I'm not aware of any.
Ms. Foster, has your attorney advised you of the minimum and maximum sentence to each charge that you're pleading to?
Yes, he has.
The minimum maximum sentence for theft of services is 1 to 5 years to serve. And the maximum for possession of a false identification card and giving false information to a law enforcement officer are both 12 months to serve. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for theft of services, 5 years to serve 1 year on weekends, credit for time served, balance on probation, and for possession of a false identification document and giving false information to a law enforcement officer, both 12 months on probation. Restitution in the amount of $3,041.75 to be paid through probation to N at Peachtree, that's N-I-N-N at Peachtree. Their address is 330 West Peachtree Street, Atlanta, Georgia. Do you understand that the court does not have to accept this recommendation? The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another.
I didn't hear that, Judge. I don't know.
I didn't either.
Yeah.
Me neither.
Do you understand that those are what the state is recommending and that I'm not bound by the state's recommendation?
Yes, I heard her.
Okay, great. But you heard it and you understood it.
Yes, sir.
Great.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, I know that.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea conviction may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, I do.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
How do you plead to the charges of theft of services, possession of a false identification document, and giving false information of a law enforcement officer in indictment number 18 SC 161602?
I'm guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Foster. Your Honor, had this case proceeded to trial, the state would have proven that on August the 1st, 2018 at 330 West Peachtree Street, Atlanta, Georgia, in Fulton County, officers responded to their location to a fraud call regarding fraudulent activity placed on a card at that location, which is a hotel. Upon arrival, officers spoke with the manager of that location, who had informed them that the defendant, Ms. Foster, had purchased 2 rooms at the location currently and had purchased other rooms dating back to July the 1st, 2018, all of which were purchased using a credit card that they ran, and it came back to different numbers than that which was actually printed on the card. Officers went up to the room that the defendant was currently occupying, which was room 415 at that hotel. They knocked on the door, and the defendant identified herself as Tina Portia Troutman with a date of birth of 11/6/1972, an identification card out of Louisiana. The officer attempted to run information on ACIC and nothing came up. The officer then tried several unsuccessful attempts to obtain the correct identification information from the defendant. Due to the misinformation, as well as the multiple records from the hotels showing different information and states the origin of the credit card. The officers placed the defendant into custody. The defendant's room had multiple credit cards not belonging to her, which were recovered, as well as a Georgia's driver's license belonging to a Miss Portia Troutman, the name which was provided to law enforcement officers on their arrival. Later during investigations, officers were able to obtain the defendant's real name and real date of birth and transported her to Fulton County Jail. The defendant does have, to jail. The defendant has prior convictions, similar convictions as to this one, dating back to 2016. That was a first offender that was revoked. This was a forgery in the first degree out of Gwinnett County. Disposition date was May the 13th, 2016. Again, that was conviction, or that was completed under first offender, but it was eventually revoked later. Then she has 2 Fulton County financial identity frauds and financial transaction card frauds, a 16 SC case and a 17 SC case. Because those date back in time, the time frame was similar to this one. I give you those SC numbers: 16 SC 140999. That disposition date was February the 26th, 2018, and as well as 17 SC 153011, which also had a disposition date of February the 26th, 2018. After actually having several conversations with Mr. Franklin on this case, I've spoken with my supervisor, and he gave me some mitigating factors that Ms. Foster has gotten her life together since this that happened back in 2018. She does have a job, or it was communicated to me that she has a job, and she's stable or more stable now than back when she was committing these crimes. So the state felt, instead of punishing her with consistent time in prison, that we will look more at a weekend situation so that she can remain, or she can keep her job. I did just meet Mr. Melnick on this case, and we went ahead and closed out the case. But a lot of this conversation has been going on for a while now, and this is the best resolution that we felt like we can come to in this case.
Okay. Well, thank you, Mr. Franklin, for advancing things, and then Mr. Melnick for coming in as the closer to do what you could do. Ms. Crawford, are either of the cases that Ms. Foster picked up and pled to in 2018, are either of those still open?
She's currently on probation, Judge, for the 16 SC 140999 case in Fulton County. She has 4 years, 8 months, and 21 days remaining on that case. And she also has an open probation case in Gwinnett County.
Okay, but the 17 SC case is closed out.
That case is inactive, yes, sir.
Okay, all right. And your understanding, Ms. Hall, is that Ms. Foster had 2 rooms at the inn at Peachtree?
Yes, Your Honor.
And that she provided a means of payment that turned out not to be valid, or that she just hadn't paid for the rooms, and then when it came time to pay, she was trying to avoid paying? I guess I missed that piece.
So the incident date, the day that she got arrested, was the day that the hotel decided to call the police, because they noticed that the car that she provided previously in the month, it was fraudulent, and they didn't get paid for that. So when they called the police, she just so happened to still be there renting rooms that she hadn't paid for at that moment.
Okay, all right, thank you. Mr. Melnick.
Yes, Your Honor.
Whatever you want to say.
Your Honor, this is a negotiated plea. We would ask that you accept it. Ms. Foster has done 48 days in custody between 2018, when she was initially arrested, and the date of her arrest today, or the date of her arrest for which she is presently in custody. Apparently, she was hospitalized in March of this year. She's had a number of health problems. And that was what caused her to miss the calendar call that I believe was on March the 2nd, but she's been in continuous custody, Ms. Foster, since May the 8th, is that correct? Right. And she had spent 21 days in custody between July 31st of 2018 and August the 21st of 2018 when she was initially arrested on these charges. She does have gainful employment waiting for her upon her release from custody. So what I had calculated is that if she's given credit for the 48 days that she's already served, that would leave 28 weekends for her to serve in custody. Your Honor, I would ask you to consider giving her 1 weekend to kind of get herself acclimated. And I'm sorry that I'm having to call my calendar up here, but that she be allowed to begin her weekends beginning on Friday, June the 19th at 6:00 p.m. and that the weekends run Friday to 6 to Sunday at 6 until she's completed them.
What is the work that is ready and waiting for you, Ms. Foster?
Right now, I have a job. Right now, I have a job working for Amazon. We're delivering packages. I've just started that job, but that is a consistent job that I've had right now for income. My other job, they actually closed down since I've been in here. I've known. So now Amazon will be my only income, and they pay pretty good for me delivering, so I can be able to at least provide for my family. My son has 1 kidney. I have to go to dialysis with him weekly, and then I have health issues where I have to have surgery soon. I have fibroids, which is bringing my hemoglobin level to about a 5, and making me get blood transfusions. They tried to give me one here, so I was trying to get my health together while I'm out.
Okay. So you deliver for Amazon. You either drive one of those vans or your own vehicle, and you're out delivering things in the metro Atlanta area. Yes?
Yes.
And you were doing that before you got picked up on the bench warrant?
Yes, I was.
Okay. And you have a place to live?
Yes, I do. I'm gonna be living with my mother, and I have to help her because she just lost her job also. They're closing down. So it's just me and my son and her. And my son has 1 kidney, so she's not been able to take him to dialysis since I've been in here.
Okay, so the household would be your mother's household, and in it would be you, your mom, and your son.
11-year-old son.
11-year-old son. Okay. And your health situation, and you don't need to provide any more details, but you're going to need to be getting some health care soon as well. Is there any reason to believe that you would be in the hospital long enough that it would run into some of these weekends we're talking about? Or what do they tell you in terms of it's outpatient, or you need you to be in the hospital for 3 weeks?
It will be outpatient healed. Once I have the surgery, I'm outpatient, so I can heal at home.
Okay. All right. And tell me why you think you have moved past this time in your life where it sounds like you were pretty deep into the fraud and the fake credit cards and all this. I mean, that can be lucrative. And so that can be alluring to someone who is looking to make a quick buck. Why is it that you think you've moved past that?
At that time, I had a boyfriend, and the boyfriend was pretty, he was pretty heavy into, I didn't know that he had all of this stuff going on. I just was kind of being with him, kind of knew, you know, a little bit of what he had going on, but I have not talked to him since this incident has happened at all. So I've tried to contact him, his mother, go to his house. I haven't even heard from the guy. So I just look at it like I was being used, and I should have known better. So ever since then, I've just been trying to take care of myself and just do
Okay. And this boyfriend doesn't have any connection to your son. He was a romantic interest of yours.
Yeah.
Okay. All right.
We were together for about 6 months.
Okay. Well, but you have these cases from 2016 and 2017 that sound like they're somewhat similar just by the nature of the charges to what happened in 2018. If you were with this boyfriend for only 6 months, that doesn't explain the 2-3 years.
Yes, before then, I had my brother who I was dealing with. He's actually incarcerated now. He was into that type of stuff, and that's what made me, you know, kind of go that route, because he was making good money. And I said, okay, and Now I don't even deal with my brother at all. He's been incarcerated for over a year. I think he's serving 5 years, so I don't even deal with him at all either.
If and when he gets out, would he come live with your mom?
No, not at all. We only have the same father, not the same mother.
Okay, got it. Okay, Mr. Melnick, are you comfortable having us work through the open probation today as well?
Yes, Your Honor.
Okay, we'll do that when the time is appropriate. And Ms. Foster, you're pretty sure that your job with Amazon is still there for you, even though you've been locked up for a little while?
Yes, yes.
Okay, and who will take care of your son on the weekends if you're gonna be going into jail for a few weekends?
My mother, she's willing to take care of him.
Okay, you're lucky. Will your son need, I don't know how often he has to get dialysis. Would he need dialysis on the weekends?
No, he get it once a week, and that's on a Tuesday. I had it scheduled for every Tuesday, but my mom couldn't take him during the time I've been in here.
Okay, but if you're doing delivery work, you'll build into your schedule time to get your son to dialysis on Tuesdays, and weekends won't interfere with that. Okay. All right. I think I got it. So Ms. Foster, I do find there's a factual basis for your plea, that you knew what you were doing and were sort of leaving imaginary life of being someone else and using other credit cards, et cetera. And that quickly caught up with you. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. You may not be excited about it, but you all on your own, with advice of 2 lawyers you've been working with, have decided that the right thing for you to do is enter a plea. Is that correct?
That's correct.
Okay. And a knowing plea is one where you've understood all the things we've been talking about, all those rights that Ms. Hall talked to you about. Have you understood all the things we brought up?
Yes, ma'am. Yes, sir.
Do you have any questions?
No, not at all.
Okay. Well, I'm going to sentence you, Ms. Foster, pursuant to the Probation Options Management Act. And what that means is that while you're on probation, if you have a technical issue, let's say you're behind on your restitution, you agree that you're going to pay a certain amount each month and you fall behind or something like that, you don't have to come back to me to work through that. You'll work through it with probation. It really would only be if you catch new charges, which would be real unfortunate for you and your son and your mom, that you come back in front of me. I will require, well, I'll go through the conditions of your sentence in a minute. So I'm going to sentence you on count 1 to 5 years to serve 1 year. And that 1 year is reduced to time served. The balance will be on probation. Counts 2 and 3 are going to be 12 months to serve. Those will be reduced to time served as well. So you're going to have 4 years probation. A special condition of your probation is that you pay $3,041 in restitution to the inn at Peachtree. Of course, you're not going to give anything directly to them. You will provide the money as you're able to pay it. And this is not a debtor's prison kind of thing. We'll look at what you're earning and the important expenses you have, taking care of your son, et cetera, and then figure out what's a reasonable amount that you can pay regularly. And you'll get that to probation and they'll get it to the inn at Peachtree. You are not to open any bank accounts or credit card accounts without getting that approved by probation. That doesn't mean you cannot have a credit card. It doesn't mean you cannot have a bank account. But if you're going to open something up, you got to make sure that probation is aware that you're doing it. You are going to serve 3 months of weekends at the jail. And I'm going to look at the calendar as well. But this is a special condition of your probation. And what that means is if you miss a weekend without letting probation know there's an issue, I'm gonna come up with a hypothetical. Say your son has a fever and you're not comfortable, you don't think it's safe for him for you to go in that weekend. You need to let probation know in advance. hey, probation officer, I can't go in this weekend. My son is sick. You need to document that. We would move that weekend to the back end of the 3 months of weekends. But what we would do is have you were saying, Mr. Melnick, starting on the 19th?
Yes, Your Honor.
Okay, so your first weekend would be the weekend of June 19th. That's a Friday. And you would need to report. I'm not quite sure where you report, if it's to Union City or to Rice Street. I don't know if they take people directly at the South Annex, but you and your probation officer can sort that out. But you would need to turn yourself in 6 o'clock on Friday, the 19th. And as I mentioned, it's going to be 3 months worth. So let me just look at 3 months. That would be 1, 2, that would get us to your last weekend is going to be the weekend of September 18th. And you'll again turn yourself in every weekend. 6 o'clock Friday, you get out by 6 o'clock Sunday. Any weekend you miss with approval, like I said, your son's sick or something like that, they'll just move to the back end. So if you were to miss a weekend in August, then your last weekend would be the weekend of September 25th. We just keep moving those back. But you need to get approval in advance. It doesn't work to let your probation officer know on a Tuesday, hey, I missed last weekend because X or Y or Z. That would be a violation of your probation. And that's the kind of thing that might come back in front of me. And what I might do is say, you know what, let's just mash all those weekends together into however many weeks that is, and we'll just serve them back to back to back to back, which will interfere with work and interfere with your ability to take care of your son. So it is important, as much of a headache as it may be, that you take care of those weekends. That will allow you to work, and it'll allow you to get your son to his dialysis. And those were the conditions that I had in mind, Ms. Hall. Oh, and stay away from the inn at Peachtree. Don't go there as a paying customer or a non-paying customer. Stay away from the inn at Peachtree. Anything else, Ms. Hall?
No, Your Honor.
Okay. Mr. Melnick, I modified that a little bit. I'm a little leery of having endless weekends on probation because life conspires to make that difficult for the client. It's also a burden for probation, keeping track of it. I structured it a little differently because if I pronounce the sentence the wrong way, probation actually doesn't kick in until your client's done with all the weekends. And then there's no one monitoring the weekends, and then things get even worse. So it's actually going to be a condition of probation rather than your sentence is to serve weekends. Do you have any questions or concerns about the way I pronounce the sentence, Mr.
No, Your Honor, it works in Ms. Foster's favor as far as I can see. So I don't have any questions. I appreciate you doing that.
Okay. And I am prepared to take care of the revocation that would flow from this for the Fulton County case. I can't control the Gwinnett case, what may come out of that. But if you waive Ms. Foster's due process notice rights, we can handle the 16 SC case as well.
That would be great, Your Honor. Thank you.
Okay. So Ms. Foster, in light of your conviction now, your guilty plea conviction in the 18 SC case, in the case of 16 SC 140999, I will, so these things track each other more closely. I'm going to revoke 8 months and 21 days. I will reduce that to the time you've served, and then I'll reinstate the balance on the 16 SC case, the basis of the revocation being this new conviction. Ms. Crawford, do you need anything else from me? I'll put you and Mr. Melnick and Ms. Foster in a chat room so you all can talk. Do you need anything else for what you need to do?
No, that's it, Judge.
Okay. Last thing, I do not have in front of me your accusation. I'm going to need to, I've actually sent it to the printer, but we'll be working off a copy of the accusation, Ms. Foster, and you've already waived that, as has Mr. Melnick. Normally, if we were all in court together, you would sign the accusation. Mr. Melnick would sign it and Ms. Hall would. but I'm gonna sign it for you so we can get you out and on your way. Do you authorize me to sign the guilty plea on your accusation, Ms. Foster?
Yeah.
Mr. Melnick, may I sign your name?
Yes, Your Honor, please.
And Ms. Hall?
Yes, Your Honor.
All right, well, I'll do that when I get a break to go do that. And I think that takes care of Ms. Foster's case. Anything else, Ms. Hall?
Nothing from the state, Your Honor.
Mr. Melnick?
That's all, Your Honor. Thank you.
All right, Ms. Foster, I hope this works out better for you, okay?
Thank you so much, Judge.
All right. Mr. Forte, are you good with, oh, I need to move the three of you to the chat room. Hold on one second. But before I do that, Mr. Forte, do you need a break or are you ready to go to the next matter?
2 minutes.
All right, we'll take a 2-minute break. When you're back on the screen, we'll get going. I'll move these folks to the chat room and then whoever's there on 5 South, we'll get to you in just a minute.
All right, that'll be position 2.
Great, thank you. So we're not on the record, but Mr. Franklin, it sounds like you are ready with Mr. Strozier's negotiated plea. That's what we're going to be doing next.
That is correct.
Great. When we get Mr. Forte back, we can do that. I'm just going to stand up. You guys can be at ease for a minute.
Okay. Good morning, Raymond.
This I got a visitation with you today.
I'm sorry, say it again.
We got a visitation.
Do we have visitation today?
Yeah.
I don't have anything scheduled with you. I don't know if you can see anybody else.
Yeah, probably somebody else. Everything still the same for yesterday?
Yes, sir.
What about probation?
We're gonna talk about all that when we get back on the record with the judge.
Yes, sir. Yes, sir. You look tired. Hey, man, I read.
Hey, Mr. Franklin.
Morning, Darnell.
Morning, Mr. Franklin. You ever get in contact with my people?
I sent him a text message. I hadn't heard back from him.
Thank you.
Mm-hmm.
You ready, Mr. Forte?
Ready, Judge.
Great. Okay, let's turn to position 2 on our calendar. State versus Raymond Strozier, 20 SC 175390. Good morning, Mr. Strozier.
Good morning, sir.
Mr. Strozier, I am told by your lawyer, Mr. Franklin, that you are prepared to go forward with a negotiated plea. Is that correct?
Yes, sir.
Ms. Hall, is this to the charges as they are or to reduce charges?
To reduce charges, Your Honor. For the record, the state is amending the charge of armed robbery to theft by taking felony. OCGA 1682.
Okay. Well, Mr. Strozier, before we get started, I need to make sure that you are willing to go forward in this remote fashion. You are on 5 South, you're not here in courtroom 1D. Do you waive your physical presence here in court, and do you allow us to go forward with this virtual setting?
Yes, sir.
You normally would have your lawyer, Mr. Franklin, sitting right next to you so that if you had any questions, you could just lean over and whisper in his ear and he could answer your questions. We can't do it that way. Do you waive having Mr. Franklin right by your side?
Yes, sir.
What I can do, if it becomes necessary, is put you and Mr. Franklin in a private conference room. I don't know how private it'll be for you. Whoever's there in the background will be able to hear things. But Ms. Hall would not be there. I would not be there. The court reporter wouldn't be there. It would effectively just be you and Mr. Franklin. So if something comes up where you need to speak with him in private, will you let me know?
Yes, sir.
Okay, we'll make that happen. All right, last thing before Ms. Hall puts you under oath. In just a moment, she's going to swear you in, and it'll be important that you answer all of her questions and mine truthfully and completely. If at any point you cannot hear what's going on because of the connection, or you just don't understand what someone said, or it's just different from what you expected, will you let me know by raising your hand so that either I can help you with it or we can get you and Mr. Franklin talking?
Yes, sir.
Great. All right, Ms. Hall.
Thank you, Your Honor. Mr. Strozier, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Raymond Strozier.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
23, 11th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with armed robbery and reduced by the state to theft by taking?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Franklin, about all the facts and circumstances known to you regarding the charges in this indictment, any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
You waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, for purposes of this plea only.
Mr. Strozier, have you been arrested on these charges?
I came from prison. They brought me from prison back to Rice Street. So yeah, I guess you'll call it.
I asked because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
Mr. Strozier has some probation matters that he's also being held on because of this incident, but nothing else particularly towards this. He was brought here on a hold, so that warrant is what we're kind of answering to.
Mr. Strozier, has your attorney advised you of the minimum and maximum sentence to the charge that you're pleading to?
Yes, ma'am.
The minimum maximum sentence for theft by taking felony is 1 to 10 years to serve. Mr. Strozier, do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 10 years to serve 5 years, commuted to time served, balanced on probation on the theft by taking felony to run concurrent with your other 2 open probation cases, which is 16 SC 140423 and 15 SC 135653. Ms. Forte, did you get that? Ms. Forte, you good? Maybe. Do you understand that the court does not have to accept that recommendation, but the court can sentence you to the maximum on this charge, which is the 10 years to serve?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other convictions in this jurisdiction?
Yes, ma'am.
Do you understand that do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
My apologies. Do you understand that you're not allowed to possess or use a firearm?
Hold on one sec, Ms. Hall.
It broke up.
I think there's background noise at 5 South that's making this kind of tricky for Zoom to stay focused on the speaker, because Ms. Hall will be talking and then you can hear background chatter on 5 South, and that pulls Zoom's ear, if you will, away from Ms. Hall. So keep trying, Ms. Hall, but we may have to pause from time to time because, of course, Mr. Forte needs to be able to take this down. And sometimes you'll go silent, Ms. Hall. I don't think there's any issue with what you're doing. I just think that the microphone at 5 South takes over because of the background noise there.
Okay. Mr. Strozier, do you understand you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport,
Is it possible for the deputies on that end to inform who was ever in the background to be quiet?
I think that was thunder.
Oh. Okay. Well, I'm gonna keep going.
Okay.
Do you understand it may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering the plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
This is an Alfred plea.
Alfred.
Okay, Your Honor, can I have a moment?
You may. Had you told Ms. Hall it was an Alford plea, Mr. Franklin?
Yeah, 1 second.
There is thunder.
Yeah, it's thunder.
Here and there.
We'll proceed as with it as a straight plea, Your Honor.
Okay.
Mr. Strozier, I'm gonna ask you that question again.
Yeah, ma'am.
Is it your decision to waive these rights? And enter a guilty plea because you're in fact guilty? I'm sorry, y'all. That may be my internet. Did you answer?
The internet cut out.
My internet?
Try one more time.
Okay. Mr. Strozier, is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
He said yes.
Okay. I'm sorry if my internet is cutting in and out. It's storming on my side of the world. So sorry, you guys.
No, it's okay. It's storming here as well. It sounds like there's a truck driving over the ceiling of the courtroom.
Okay, so
But I'll make it extra clear. Mr. Strozier was asked whether he was waiving his rights and entering a guilty plea because he was in fact guilty, and his answer was yes.
Yes, sir.
Okay. Thank you, Your Honor. Mr. Strozier, how do you plead to the single charge of death by taking in indictment number 20SC175390?
Plead guilty.
And is that guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Okay. Thank you, Mr. Strozier. Your Honor, I'm gonna if this case had proceeded to trial, the state would have proven that on June the 14th, 2015, at 3100 Gobby Road, College Park, Georgia, in Fulton County. Officers responded to that location in reference to an armed robbery of a cell phone. The information that we were given by the victim was that her and the defendant was inside of her home. The defendant asked to use her cell phone. He did use that cell phone, but while on the phone, he was referencing someone picking him up in about 2 minutes, and he signaled to the front door. She went to the front door with him. They went outside. When she stepped outside, someone else put a handgun to her head and told her to go back inside of the house, which she did, to call 911. So then when she stepped back outside, the gun was placed to her head again by that same individual, not being the defendant. She went back into the house after being told to go back in the house for the second time. She went back into the house. After she waited a few minutes, she came back outside, at which point she said that she saw the defendant get into the car with the individual that put the gun to her head. And at this point, the phone wasn't returned by the defendant. The defendant still had the victim's phone, according to her. This is, I know it's pretty strange that we're reducing this armed robbery, but during our investigation, as in the state, We do feel like there are holes in the completeness of this story as to what happened that day. I have been in contact, and as well as Ms. Rolak has been in contact several times with the victim's mom in this case, to try to understand the pieces that we are missing. And her mom has assured us over a course of months, even when this case first got indicted, that her daughter didn't have a phone, that she would have her reach out to the state. Later on, probably a month ago, she told me that her daughter has a new number, and I did tell her the concerns that I was having with this case if it were to be presented at trial. I felt as though if I voiced that to the mom, she would have her daughter call me back because this is a serious case. Still no communication with the daughter, nothing's wrong with her. I've confirmed with the mom that she's well and okay, and she can return my call if she chose to. All that being said, along with the fact that the defendant picked up 2 additional cases after this case in 2015, I don't know how this case was missed in the mix, but he did get time, 5 years, I believe, on one of those cases. I know Mr. Franklin will give you all this, but he did serve 5 years, at which point I believe he just finished or is about to finish. And so we're kind of trying to date this back to if he had been sentenced with those other 2 cases, the 2016 case and the 2015 case, which he would have to be revoked on, but I believe those 2 are back to those are Judge Legura's cases, and they're back to. So, but that's how we came up to this resolution, with the issues with the victim, with having all the information that we have. There is no body cam, there's no surveillance. It's pretty much just stories. And it's because I can't clarify more of that story. And no, I'm not saying that she did not have her cell phone taken. Her cell phone was taken, but I'm not sure as to what all happened there that day. And because of that reason, we've come up with this resolution as being one in which we feel it'd be the best resolution shy of trial, trying to figure out all the pieces to this case.
Ms. Hall, do you know, is Ms. Graham, that's the young lady whose phone the defendant took,
Yes.
You said she's healthy, so she's not failing to call you back because she's in a hospital or something. Is she an adult? Is she old enough? She's not 14 years old?
No, Your Honor. She doesn't even live with her mom. That's why it's been so hard to get in contact with her. I try to call back in the evening when I think she's around, and then she told me she doesn't live with me, but I promise I'll have her call you. And I mean, she's assured me, and I feel like she is making those efforts, but until we have that conversation with a victim, we don't know what their position is, or this was 5 years ago, so maybe, I don't know. So. Okay,
well, that's my next question for you. It was 5 years ago. In fact, in 9 days, this case will be 5 years old, and it was indicted. It's one of the last indictments to sneak through a grand jury in this county before we had to shut down. Why? I know you don't do the indicting side of things, but what have you been able to learn about why 5 years later your office suddenly jumped on this one?
So I've been researching it to try to figure out what happened here, because warrants were taken out back in 2015. And the only thing that I can gather as in putting the pieces together on my end is that we didn't receive the packet from the agency, because when we received it, that's when we wrote it up for the indictment. And this year, we wrote it up once he went into custody, or once they learned he was already in custody, and gave us all the information. We indicted it. We did not shoot. We realized that the aggravated assault, the gun charges, all that, the statute had ran. But, and this was something the complaint room looked into before they even charged the armed robbery. So I'm gathering that it was not presented to our office until this year. Don't hold me to that, because I'm not 100% sure. I'm working with just the system, but that's what it looks like for me.
Okay. I appreciate you being candid about all those things. It helps explain a little bit this recommended resolution. Mr. Franklin, there seem to be a couple other moving parts. I've been looking into Odyssey, and there is a case from Judge Cox where your client got 10-5, but it looks like he's been paroled. And there's a case from Judge LaGrua where he also got 5 years to serve and 15 years probation. Tell me what you think all the moving parts are, and where Mr. Strozier is in terms of DOC custody or county custody or what?
Okay, so I believe I can piece everything together sequentially. Mr. Strozier has been in custody since June 23rd of 2015. He resolved the cases before Judge Cox and was sent down the road. He was paroled, or was given a letter of parole indicating when he would get out, November 26th or November 29th of last year. Those warrants that Ms. Hall just referenced were connected such that, as opposed to being released with a bus ticket to go home, DOC would have contacted Fulton County and said, hey, y'all have these warrants, what's going on with them? I believe that to be the impetus as to why he was indicted in 2020 and not before. The state didn't, well, not Ms. Hall per se, but the state didn't investigate it. They forgot about it and lost it. And he, served his time on other matters. Those charges were gathered, collected when he was just exiting the age of being a juvenile. He's 23 years old now. I believe he has a child on the way, if I remember correctly. Isn't that right, Mr. Strozier? Not on the way, but was on the way when he went to prison, and
Yes,
he's
sir.
had a chance to see or hold her since that point in time.
Meaning, just because what you said was confusing, he's not about to have a kid. He has a kid, a daughter, who's 5 years old that he's never met.
That is correct. I said that confusingly.
Okay.
So I approached Ms. Hall and explained that portion of the situation. Like, look, it's not really a really fair assessment of everything to have the guy serve a sentence, especially when in Fulton we have a really good system in terms of resolving cases together, and then to kind of reapproach this and say, hey, let's make him go do some more time for this thing that nobody looked into for a very long time. But additionally, I also believe I can fill in the gap as to the holes in the case that Ms. Hall referenced. In the bit of investigation I've been able to do, what I've learned is that the young woman and Mr. Strozier were involved sexually, that he was on curfew related to the earlier case, the 2014 case, and his mother was on the way to pick him up from the young woman's house, but she didn't have the address. So he exits the house. The woman is still talking on the phone to Mr. Strozier's mother, but she's not in eyesight of Mr. Strozier anymore. Mr. Strozier ends up making it out to the main road and gets picked up by his mother there. I believe, as best as I can gather, that perhaps she was outside thinking Raymond may come back and was robbed by someone else, but needed to kind of get a report together to make an insurance claim or something of that effect. So we would have had if we had gone forward, we would have had to subpoena phone records and validate all those kinds of things. But given the totality of the circumstances, giving Mr. Strozier's desire to see his child, to get back with his family, we embarked upon negotiations to try to see if we could find a resolution that made some sense. Being that he has served a chunk of time, that he's only 23 years old, and he's basically spent the chunk of his late teenage years and early adulthood in custody, we think that it makes sense that he now has the opportunity to show that he's learned from his time in custody and to live his life and not be held back from a case that, just wasn't investigated by the state.
So do you think, Mr. Franklin, that this plea would have probation consequences for the oldest of there are three other cases? There's a 16 SC and a 15 SC. Those are both addressed through this parole letter. I've got it on the screen in front of me. But Judge LaGrua's case, the 14 SC, isn't covered by that. And as she sometimes does, she put a real long probationary tail on the 14 SC case. Does this, if it's a 14 SC indictment, then the conduct in this case has to post-date it. It does. The conduct in the case we're talking about was from June 2015. So setting aside the delayed indictment, it seems like this plea could have probation issues for the LaGrua case.
That's correct. There is if you look at his booking screen, it does show a probation hold for that 14 SC case that would be Judge LaGrua's case.
Okay.
I wasn't aware that it was a back to Judge LaGrua.
I don't know that it is, and she and I have a comfortable enough business relationship that I'm okay dealing with it. I just wanted to make sure you weren't thinking that there wasn't anything to do with the 14 SC case. I think there is in light of today's plea.
Yes, sir, there is. It needs to
Okay.
be addressed concurrently.
Okay. All right. I think I follow all that. The stories conflict somewhat, but that's not uncommon. What doesn't conflict is that Mr. Strozier's been in for 5 years, and whether you want to attribute the 5 years to the burglary case or the robbery case, those would be Judge Cox's cases, or this case, whatever you want to call it, it's still 5 years. And all of those years come after this case occurred. And so whatever effect 5 years of service would have, or 4+ in terms of deterring conduct, letting Mr. Strozier mature a little bit, it's happened. The good or bad, it's happened to Mr. Strozier. And so I think it is productive to look forward to say, well, what can we do to get Mr. Strozier staying on a good track? Mr. Strozier, where will you live when you get out?
3121 Dotson Drive, East Point.
3121 what drive?
Dotson, Dodson.
And what's there?
My sister and my brother, my oldest brother, and my mom.
So is it your mom's house?
It's really my brother's house, but yeah, my mom's house. She stayed out too now.
Okay.
It's a
So
duplex house.
Your brother and your mom and your sister live there?
Yes, sir.
And there's room for you? You wouldn't have to stay on the floor?
No, I ain't got to stay on the floor.
Okay. Your daughter, does she live with her mom?
Yes, sir.
Have you stayed in contact with your daughter's mother while you've been in prison?
Yes, sir. I got visitation after this.
Okay, so you've actually seen your daughter?
Yes, sir. Visitation in prison and here.
Okay. But you haven't been able to spend time with her outside of custody. And does your daughter and your daughter's mother, do they live in the Atlanta area?
They stay up the street from my mom.
Okay. And your mom stays with your brother?
Yes.
Okay.
They stay. Yeah. They stay.
All right. You ready to try something other than be in prison for a while?
Yes, sir.
Amen to that. Okay.
Amen.
Well, Mr. Strozier, anything else you want to add?
No, sir. Thank you. Thank y'all.
Don't thank me yet. I haven't sentenced you yet. Wait till the dust settles, then you can decide.
I don't know.
So I find there's a factual basis for your plea. It sounds like it would have been a complicated case for the state to prosecute, in part because of its age. But you're pleading to theft by taking. And based on what the state has alleged, if they proved what they alleged, there would be a factual basis for your plea. I also find that your plea is knowing and voluntary, which means, first, for the voluntary part, that no one's forcing you to enter this guilty plea. It's a plea that you've decided is the right thing for you to do. Is that correct?
Yes, sir.
And it's a knowing plea, meaning you've understood all the things we talked about. Do you agree with that?
Yes, sir.
Do you have any questions about anything?
No, sir.
Okay. So what I'm going to do is, your sentence is going to be a little different than what you guys have talked about, but hear me out. And if you and Mr. Franklin have a concern about it, you guys can have a conversation about it. I am going to sentence you to 6 years to serve 2 years. You're going to get credit for those 2 years since June 23rd, 2015. So you've already served the 2 years. I'll make sure that your final disposition reflects that you've been in custody almost 5 years now. So basically, you're gonna have 4 years probation.
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act, which means that if while you're on probation, you have a little problem, not a big one, you'll just deal with probation. So if you miss a meeting with probation, or I'm making these things up, you test positive for marijuana or something like
I'm
that,
sorry, Judge.
you
Before
don't
you,
have to come. Pardon me?
I'm sorry. Could I interrupt before you get too far along?
Yeah.
So I know the importance of making sure that we have enforceable legal sentences. Since there was a reduction of charges by the state in this case,
Yeah.
I know when we have non-negotiators that involve a reduction of the charge, that there may be a limit in terms of how the court can change the actual sentence. I'm a fan of the change, but I also want to make sure that it's not anything that may complicate issues down the road.
So as I understand the case law, Ms. Hall will be given a chance to object to the sentence, which is basically 1 year less probation than she asked for. And if she objects to that, then there is an issue we'll need to work through. If she does not object to that, then the sentence stands. But the state does have the ability to, because of the charge reduction, say, we don't go along with that. So let me just spell it all out, because I want to make sure she knows all the conditions as well. And then she'll be in a position to say, we object to that, or we don't. I'm not trying to make it fall apart over 1 year of probation. If I need to come back to that, I will. I just think that 4 years is ample. Plus, Judge LaGrua still has 10 years of probation remaining on this. So in some ways, I could say I give you 1 day probation, and he's going to have probation. Mr. Strozier will have probation for many years beyond what you two had negotiated. So let me finish, and then I will certainly get Ms. Hall's input on this as well.
Thank you.
So, Mr. Strozier, if there is a hiccup while you're on probation, and it's a small one, like I was describing, you and probation will work that out. But if you ever catch new charges, meaning you get arrested while you're on probation for this case, that's the kind of thing that will come back to me, and we would need to work through that. And you would run the risk of getting revoked for a pretty meaningful portion of your probation. It'll be a special condition of your probation that you get your GED. Did you do that while you were in prison?
Yes, sir. I got my own high school diploma in prison.
Oh, well then that's not a condition of your probation. It will be a special condition of your probation that you stay away from Ms. Graham. You know who I'm talking about?
Yes, sir.
So just in case you were interested in reconnecting with her, that's not happening while you're on probation in this case, okay?
Yes, sir.
So you need to stay away from her and any address associated with her or her mother. And I'm prepared to handle the revocation in the 14 SC case. We'll need to hear from Ms. Crawford. I don't think there is any revocation pertinent to the 16 SC case because that's a parole thing. But before we go any further with any of that, Ms. Hall, let me know if you are comfortable proceeding with the way that I have outlined what I think the proper final disposition for Mr. Strozier in light of all the facts that I've heard from you as well as from Mr. Franklin. Number one of which is Mr. Strozier has served 5 years in prison.
No objections from the state, Your Honor.
Okay. So that's the game plan. Ms. Crawford, is there anything we need to address with the 16 SC or the 15 SC case, or only the 14 SC case?
Only the 14 SC case.
Okay. Then I'm prepared to go forward with that one. Mr. Franklin, if you waive any due process notice rights that Mr. Strozier has in connection with that case.
So waived.
just calling it up on Odyssey here so I can check it one more time. Just a few things from back in 2016. So Mr. Strozier, you are Raymond Herman Strozier. Is that the same person?
No, sir, that's somebody else. I'm Raymond Levon Strozier.
It's interesting. And that's what it says for the official things, the paperwork, it says Herman on it.
Somebody had used my name when I was in here last time before I went to prison.
Okay. But this is your case, the Judge LaGrua case. Did you have a case in front of Judge LaGrua?
Yes, sir. Robbery, snatch robbery in 2014.
Okay, that's the same one. All right. So what I'm going to do in that case, excuse me, is revoke 2 years of that probation, and I'll give you credit for time served since June 23rd, 2015. Then I'll reinstate the balance and not change any of the conditions. You had all sorts of conditions from Judge LaGrua, the way that case was worked out, and I don't mean to change any of that. Let me call that up again. For strange backloaded sentences. I guess you never did the Teen Challenge program?
Nah, she let me come do book reports for her on every Wednesday.
Okay, got it. Yeah, you were definitely in her program if it was book reports. Okay, so Officer Crawford, do you need any, Ms. Crawford, do you need anything else to process the revocation?
No, Judge, that's all that I need.
Okay, so Mr. Strozier, what I intend your sentence and your revocation to do, basically get you out in the next day or two. You probably won't get out today, but you ought to get out this weekend. Neither the sentence I'm imposing in the, you taking the phone, or the revocation in LaGrua's case meant to keep you in any longer. If you are still in jail come Monday, you need to reach out to Mr. Franklin and we'll figure out why you're still there. I hope that blowing 5 of the prime years of your life in prison has helped you focus on what's important, your daughter, your mom, your brother, work, whatever it might be, and that whatever was going on in your life before you got locked up is behind you now. Easier to say than to do, but you should know that we're all pulling for you to make it work out, and I hope that it does. It'd be great for your daughter for you to be a meaningful presence in her life. Do you have any questions about anything, Mr. Strozier?
No, sir.
Mr. Franklin?
No, sir.
Okay. I have your indictment here, holding it up right here. I've written on it that the charge was reduced to theft by taking. If you were here in court, Mr. Strozier, you'd be asked to sign the indictment. Do you authorize me to sign your guilty plea on the indictment on your behalf?
Yes, sir.
Mr. Franklin, can I sign for you?
Yes, Your Honor.
Ms. Hall?
Yes, Your Honor.
And anything else, Ms. Hall, for the state in this case?
Nothing further from the state.
All right, thank you, everyone. Should I move Mr. Strozier into a chat room with you, Ms. Crawford?
Yes, Judge.
All right,
Judge, I
Mr.
have a
Franklin.
quick question. I'm sorry.
Yes, Ms.
excuse
Nelson.
me. I just wanted to make sure that was 6 years to serve 2 years, correct?
Yes, ma'am.
All right, that's all I needed to know.
Great. So I'm going to move the three of you into a room, just so you can hear Mr. Strozier, what Ms. Crawford has to say about reporting to probation. The most important thing you're going to do when you get out is hug your family. The second most important thing is to show up to probation, okay?
Yes, sir.
All right, I'll move you guys there. And we should only have one person left, Mr. Presley, who I think is already there at 4 South. Mr. Presley, we got to wait until Mr. Franklin comes back from the little breakout room, and then we'll take your case, okay? Mr. Franklin, you ready?
Yes, sir, Your Honor, I'm ready.
Okay. Mr. Forte, you good to go? We'll do our last position on this calendar. It's position 1, State versus Darnell Presley. Mr. Presley is there on 4 South, 19 SC 171414. And it's my understanding we're taking a non-negotiated plea, or we're going to try to take a non-negotiated plea. Mr. Presley, how you doing this morning?
Fine, sir.
Good. So here's how this is going to work. In a moment, Ms. Hall is going to put you under oath, after which she's going to ask you a bunch of your questions about your case and your rights. You need to answer her truthfully and completely. If at any point you have any questions of your own, it's important you let me know, so either I can try to answer them or Mr. Franklin can help you out. Will you do that?
Sir. Yes, sir.
All right, Mr. Presley, you have the right in normal times to be here in open court with everyone in the same room. We're having to operate a little differently because of the public health situation. Do you waive your right to be sitting here in open court?
Yes, sir.
You also have the right to have your attorney, Mr. Franklin, right there by your side so that he could answer questions you might have and you guys could discuss things as you might need to. I can put you into a private conference room with Mr. Franklin if something comes up, but in general, as we proceed, you two will only see each other and hear each other on the screen. Do you waive your right to have Mr. Franklin sitting by your side?
Yes, sir.
Great. Well, then we will proceed. Ms. Hall?
Thank you, Your Honor. Mr. Presley, can you raise your right hand? Do you swear or affirm the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
No.
You may lower your hand. Please state your true, correct, and legal name.
Darnell Cedric Presley Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
22 years of age, and I've got a GED, ma'am.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with 1 count of theft by receiving stolen property?
Yes, ma'am.
11 counts of entering automobile and 1 count of possession of tools for the commission of a crime.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes, ma'am.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Franklin, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
For purposes of this plea, yes.
Mr. Presley, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum and maximum for theft by receiving stolen property is 1 to 10 years to serve. The minimum and maximum for entering automobile is 1 to 5 years to serve. And the minimum and maximum for possession of a tool for the commission of a crime is also 1 to 5 years to serve. Ms. Presley, do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state will still make a recommendation to the court?
Yes, ma'am.
Have you discussed the state's offer with your attorney?
Yes, ma'am.
Your Honor, the state's offer, or I'm sorry, Mr. President, the state's offer is for all counts, 5 years to serve 3 years, balance on probation, with restitution currently at $4,495.63 to be paid two various victims, I will probably reach out to Ms. Crawford and give her those names and addresses. The balance to probation. Mr. Presley, do you understand that the court can authorize any sentence authorized by law, including a higher sentence than what was recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation? You say yes?
Yes, ma'am. I understand.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
I understand.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, and the ability to obtain employment.
I understand.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
I understand.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
I understand.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charges of 1 count of theft by receiving stolen property, 11 counts of entering an automobile, and 1 count of possession of a tool for commission of a crime in indictment number 19 SC 171414?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, had this case proceeded to trial, the state would have proven that on August the 6th, 2019, officers were called out to 2840 Norman Berry Drive, Berry, East Point, Georgia, in 30344 in Fulton County. Officers received a call from a witness that was witnessing the defendant along with a co-defendant, Mr. Underwood, break into several cars at that location. Officers came out to the location. When they came out to the location, both defendants jumped over a fence. They were later apprehended by officers after being given description of what they were wearing by the witness. One of the co-defendants did have broken glass and other effects from the entering automobiles on his person. He did implicate the defendant as being the person who broke into those cars, although he did have the same material that the defendant had to break, like a screwdriver. He did have the broken shattered windows glass on his clothes. But he did implicate the defendant as being the person who broke into those cars, and he just stood there and watched. There were a total of 11 vehicles that were broken into that evening, and there's a total of 13 victims. Ms. Rolak and I have been able to get in contact with 10 of those 13 victims, as in getting restitution amounts, because there were several windows that were broken into and the items that were taken from the cars that weren't recovered or that was damaged in the process of fleeing. And that's where we get the restitution amount, the $4,495.65 from. That's a total of 10 victims. The state is requesting, if possible by the court, if we could have 10 additional days to get the restitution amount for those 3 outstanding victims. We do have our investigator working on those victims to locate those victims. She has been working for quite some time now, trying to locate those 3 individuals. But other than that, I'm sorry, Your Honor, the defendant does have prior felony convictions. He has 4 prior felony convictions dating back to 2017. He had a theft by receiving stolen property out of Fulton County. The SC number is 17.
I've got those in front of me. If it's the same thing that's on the repeat offender sheet for Mr. Presley, I've got 2 Fulton, 1 DeKalb, and 1 Forsyth case.
Okay, that is his criminal history, and that is all from the state, Your Honor.
Tell me a little bit, the factual basis that I'm not picking up on is the stolen car. I get breaking into a bunch of cars, having the tools for the commission of the crime, but count 1 alleges that Mr. Presley and Mr. Underwood had a stolen Hyundai Elantra.
Right, I'm sorry, Your Honor. I tried to summarize from the actual report. So the vehicle that was the theft by receiving stolen property charge was the vehicle that they used to get out there to the location that the officers were able to identify when they were investigating.
Okay, so they allegedly showed up to break into a bunch of cars driving a stolen car.
Right, and that stolen car was reported stolen out of Clayton County, I believe. Yes, Clayton County. Okay,
last question for you. What is at 2840 Norman Berry Drive?
It is a apartment complex, I believe. I was trying to locate the name, but it is the Norman Village.
That's not you. That's someone on 4 South. So this would have been breaking into people's cars at their home, not at a Walmart.
I'm assuming, yes, Your Honor. I reaching out to the victims, I didn't ask them if that was their home because I assumed that it was an apartment complex.
Okay. Got it.
But I'm assuming that it's Norman Berry Village, which is an apartment complex. So yes, Your Honor.
Great. Thank you. Ms. Crawford, are any of Mr. Presley's cases open and active? I see 4. Do you have more than 4? And then is any one of them open?
Judge, I only have 3 and none of them are open in Fulton. Only the Forsyth case is open.
Okay, so the Forsyth, there could be business that Mr. Presley needs to take care of in Forsyth.
That's correct.
Okay, how much time, can you tell how much time remains on that?
Let's see, 10/17 of 2027. Give me one moment, I can add up and see how much
No,
time.
no, 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 that's fine. It's open through 2027?
Yes.
Okay, so there's 7 years plus on that one. Okay, that's helpful to know. Thank you.
Okay, you're
Mr.
welcome.
Mr. Franklin.
Thank you, thank you much, Judge. So to begin, what I'll say is this. Mr. Presley has been in custody for about 300 days now. I think he's officially at 302 days. He, as you can tell from his record, has been a partner in the criminal justice system for some time. And that's a lot to say for a young man who is 22 years old. It's election season. I know your honor's not up for election or anything, but I'm reminded to kind of engage in this conversation because we hear a lot of the conversation about how society should deal with persons who are precisely in the position that Mr. Presley is in. Do we need more prison time? Do we need to seek treatment? That's kind of a debate conversation that we see a bunch that's kind of, goes head to head with one another. Mr. Presley has done prison time before. He's done a significant chunk of time here. And one thing that I believe has failed him, and he's failed himself in this regard as well, is that he has, since juvenile, since he was in YDC for some stuff he did as a child, it has been known that he's had some mental health issues. He's also had some attendant drug issues as well, that combination of which we all know that's not a good formula. And he, from what I can tell in my conversation with him, when he is released from custody, he does not have any other structure. It's just kind of like, okay, you did your time, let's go. And I think that's a recipe for the recidivist issues that we hear so much about in Fulton County. When I first got Darnell's case, we initially tried to get into drug court because I estimated that his drug issues were more severe than the things that he was dealing with mental health court. He was denied from drug court, not because of anything particular about him, but because his co-defendant beat us to the punch. And drug court does not take co-defendants. So we then began working on private placement. And I believe we had a hookup with the dorm organization or something like that. But we attempted that plea with Judge Reeder, and she did not feel that it was structured enough for Darnell. So she, at that time, of course, being the behavioral health treatment court judge, said, hey, does he have anything behavioral health? He had mentioned something to me before, but we had not been able to get any paperwork to document it that would support entry into behavioral health court. But we began working on trying to find placement, and we were finally trying to find paperwork. We were finally able to get some paperwork from persons at YDC because he never received treatment outside of custody. We were able to get that information to him. He has diagnosis for anger and depression. He's one of the people that stopped taking medication because of how it made him feel. I think he was perhaps over-medicated by a couple of dosages, and it gave him a feeling that he didn't like, which led to him trying to self-medicate with substances. If the court were to grant our request here, we are asking for a probated sentence. The judge, you have a lot of time to work here, and we would defer to you in terms of how much time you feel is necessary. We are asking for a probated sentence upon his entry into a completion of behavioral health treatment court. So I think it would maybe be like an 18-month sentence reduced to time served once he's actually be able to be admitted. And I say 18 months as opposed to just a year, because being that he's at 300 days, we may run up against that year time in terms of trying to get him placement. There currently is not a hold showing for him for Forsyth County. I've attempted to call and inquire like, hey, who's the probation officer for Mr. Presley? But because he physically reported to his probation here in Fulton, they don't have anyone assigned to him for me to have had a conversation with to kind of preview what he may face up there. So if we were able to get what we wanted from Your Honor, I have a drive up to Forsyth County to try to help Mr. Presley there, should he actually have a hold placed on him once this sentence is complete. But he's a very young man. He's got a raw deal. He's dealt himself some of those cards, but I also think that maybe the speed at which we deal with things in Fulton County encouraged some of his prior representations just to kind of speed through it. Because I know it's very easy for some of us who deal with heavier cases to say, hey, it's quote unquote just an entering auto. It's just a theft by receiving. And perhaps we didn't surround him with those things that we as attorneys should have done. And I say that as a defense bar, not necessarily on the state or the judges who played him out before. So what we're asking for is an opportunity for us to see how he's able to perform on the outside with the assistance of the Behavioral Health Treatment Court program. The final thing I'd ask, Ms. Hall mentioned warning about 10 more days to get restitution information from the other victims of the charges. We have no issue with that. Although I would also want to make sure that we get clarity in terms of whether insurance claims were filed and that they aren't kind of double compensated if they in fact were reimbursed somewhat through their insurance companies.
Okay. It sounds like a lot of this would have been below a deductible anyway, but critical question. Mr. Presley is not in BHTC yet. Do we know whether they would take him?
Yes, when we had our conversation inquiry calendar on Tuesday, I had found out the day before that they would accept him.
So you have an email from Mr. Tucker or someone saying he's in?
Yeah, specifically what they said, we were like, hey, we're waiting to hear back. Like, what's the status? And they said, we're working on his housing.
Okay.
If you give me a second, I might be able to find the email.
No, I'm not doubting you. I just wanted, so the way you framed it was, let's see if he can get in. That's how I heard it.
Oh,
But
no, I'm
you're
sorry.
saying he is in, as far as you understand, he's been admitted into BHTC.
That is correct.
Okay. I don't remember signing a referral or anything. Is that something that Judge Reeder had done?
Yes, I believe so. I'm not sure if it's something we just inquired with or read through the email chain.
It's been a little loosey-goosey. Formally, the way it ought to work is none of the accountability courts ought to consider someone unless they've received a referral form that at a minimum is signed by the judge. Ideally, it's also signed by the defendant or his or her lawyer so that they're not getting someone referred there who's not even interested. Mr. Presley, have you talked with Mr. Franklin about participating in the behavioral health treatment court?
Yes, sir.
Is that something you're interested in?
Yes, sir.
Why?
I ain't, be honest, I ain't got no more room for failure.
So when you were in YDCs, they gave you medication for things?
Yes, sir.
Like what?
My anger, my depression, like, acting out.
Do you have a place to stay, or is it helpful that behavioral health treatment court is looking for housing for you?
I got a place to stay.
Pardon?
I got a place to stay, sir.
And with whom would you be staying?
It's in between my mom and my girlfriend.
What does in between mean?
Like, I can go back to my mom's house for sure, but my mom.
Okay. Ms. Hall, were you aware that Mr. Presley had been denied at accountability court because the co-defendant is in, well, I should be clear, the co-defendant is in drug court. So I'm assuming that's something that you had signed off on.
No, Your
Or
Honor.
your predecessor.
Yes, Your Honor. Someone before me signed off on that case. And so, no, I did not know that he was in drug court and that was preventing him. But even with that, with his history, we just on him, if we had the other co-defendant, he probably wouldn't have got drug court, or at least it wouldn't have been a recommendation from the state. But I know I was not aware that he was in drug court and that's why he wasn't accepted. But even if he was accepted, the state still would have asked for time.
So the sentence for Mr. Underwood, the co-defendant, was 7 years to serve 3 years, balance probated, and then the 3 years were reduced time served upon entry into drug court. And apparently he had a whole nother case because it was concurrent with that other case. So Mr. Underwood's criminal history wasn't all that different from Mr. Presley's. And I'm asking just because assuming people are somewhat similarly situated, their outcomes ought to be somewhat similar. I respect drug court's policy of not having co-defendants in the same case in there. It creates a race to the door, and it's a race Mr. Presley lost. But BHTC may be an option. Well, here's what I'm going to do. I'm inclined to impose a sentence that looks a whole lot like Mr. Underwood's, where assuming Mr. Presley gets into BHTC, he's there. And then there's a healthy chunk of probation so that if Mr. Presley doesn't make it through BHTC because he gets in trouble again or walks away from it or whatever it is, there are ways for us to get Mr. Presley treatment in a more custodial setting. So I think that's how I'm going to structure it. That will allow you, Ms. Hall, to get the rest of the restitution and share with Mr. Franklin whatever documentation is there, because it's not enough for a victim to say, hey, I need $500 because that messed up my car. It need to be a little bit more than that. And I see Mr. Franklin's point that if the victims were reimbursed by insurance, then they shouldn't collect twice. I've never run into that unless it's funds beyond the deductible. But in your typical entering auto, most of what happens is not, the victim has to eat it because the deductible is larger than that. And so what they're asking for is the amount up to the deductible. But you'll get whatever paperwork you can get. I'd like to see that Mr. Presley is in BHTC, just so that we don't create a sentence that Mr. Presley's stuck in the jail because he can't then go to BHTC. But let me describe what I think the sentence is that I'd impose. And if everyone is on board with it, then Ms. Nelson can prepare the final disposition. I'll just hold off on signing it until, one, we get a dollar amount that is agreed to by the two sides for restitution, and two, we get proof positive from BHTC. And it can be as easy as an email from Mr. Tucker to Ms. Nelson saying, Presley's in, we'll take him whenever he can get sentenced. We get both those things. I can sign the final disposition and Mr. Presley can be on his way. So Mr. Presley, I do find there's a factual basis for your plea. Whatever you chose to do on August 6th was a bad choice. As best I can understand it, that's a senior living apartment complex where you were punching out the locks or breaking the windows of car after car after car. And nothing good comes out of that. And I'm not quite sure what Mr. Franklin was getting at about election season and this and that. There's never a good time to do something like that. It's that type of annoying, disruptive, low-level crime that really gets folks frustrated. You're not hurting anyone, you're not pulling a gun on anyone, but you're turning the life upside down for each of these folks. And it was a whole bunch of folks. And there's not any justification for it. And you may have been dealt a crummy deck of cards as a kid. That doesn't make it okay. And we're going to see if BHTC can help. But if it doesn't, then the way that this will likely play out for you is that you'll go down the road for a while and you'll be angry and you'll be depressed. and then this cycle is going to repeat itself. So I hope, assuming you get into BHTC, you pay attention to that opportunity and you take advantage of the opportunity to take care of things. I think, as you said, failure is not an option now. Your back is sort of up against the wall here. But I do find there's a factual basis. I also find that your plea is knowing and voluntary. Do you have any questions about anything people have been saying about your case or your rights or anything like that?
Sir.
Pardon me?
Yes, sir. What if I was to get my address changed?
So don't worry about your address right now. That's the least of your worries. If BHTC finds housing for you, that's where you need to stay unless and until they say it's okay for you to live at your mom's house. They need to be okay with the address that you provide. Unless you're saying you're thinking about moving out of state. Is that what you have in mind?
No, sir.
All right. And I'm all for you staying with your mom if that's a safe place and that's the right neighborhood for you to be in. But that's a conversation you'll have with the folks at BHTC. And if they don't need to find you housing, all the better, because that's a precious commodity. But that makes me wonder if you've really had a meaningful conversation with them. If they're spending time trying to find you housing, and I ask you and you say, I got a girlfriend's house or my mom's house, there may not have been the fullest of connections there. But I do find that your plea is knowing, since your only question was about housing. I also find that your plea is voluntary. Has anyone forced you to take this plea or promised you anything other than you know what the recommendation of your lawyer and the prosecutors are?
No, sir.
Okay. I'm going to sentence you pursuant to the Probation Options Management Act, Mr. Presley, which means if you get to the probated part of your sentence and you're done with BHTC, if you have a small violation of your probation, like maybe you get behind in paying restitution, that's a matter for you and probation to work through. But if it's something more serious, a new arrest, something like that, that'll come back to me. So what I'm going to do on count 1 is sentence you to 8 years to serve 3 years with the balance probated. And those 3 years will be reduced to time served upon your acceptance into and entry into the behavioral health treatment program. Successful completion of BHTC will be a special condition of your probation. So in other words, once you get into BHTC, you will be on probation and that 5-year clock starts running. And if you're terminated from BHTC, that's a violation of a special condition of your probation, which could result in the revocation of all of your probation. You know, I'm remembering, I don't know if this is going to be a hang up for BHTC. You can't have restitution, at least with drug court. They don't want you in drug court. Somehow Mr. Underwood is in there. So I'll see how that process works through it. But I'm not going to remove restitution from your sentence. Mr. Presley, I can't tell you right now what that final amount is. I'm going to give Ms. Hall a little while longer to see if she can track down those last few victims. But I'm going to give her a week. And if she doesn't have anything additional, then it'll be limited to the $44.95 that she's come up with so far in terms of restitution that you will owe to the various victims in your case, where you and Mr. Underwood were breaking into the cars at this senior living facility. As for the remaining counts in your indictment, that was just count 1. Counts 2 through 12, actually 2 through 13, they're all the same. Those will run concurrently with each other, and they will be 5 years probation, and they will run consecutive to count 1. So the overall sentence is 3 years to serve. That'll be reduced to the time you've served if you get into BHTC. And then you will have 10 years of probation following that. That extra probation is designed to give you time to pay off the restitution so you can try to make whole each of the individuals whose cars you broke into and damaged on August 6th of 2019. Ms. Hall, do you have any questions about the sentence as I've described it?
No, Your Honor, I don't have a question about the sentence. I do have some clarity on the restitution.
Okay, before you get there, do you have any other conditions that you'd want to see as part of Mr. Presley's probation?
Just to stay away from that location.
Okay, that's a fair point.
In trying to summarize this as short as possible, I left out that the victims come from two different locations. One is an extended stay hotel, and then the other one is the senior living complex.
Okay.
So it's away from that, the village that I mentioned when I was giving the facts, but also in-town suites located at 845 North Central Avenue in Atlanta, Georgia. That is how they were able to know what vehicle that the defendants arrived in, because they had just broken into cars at around 1:30 at the Inn Suites Hotel, extended stay hotel. And then when they looked at the surveillance from that break-in and then caught them from this next break-in, they saw the same car, and they obviously knew that that was the same car that was used at the previous break-in of those entering automobiles.
What's the address of the hotel?
The in-town suites location is 845 North Central Avenue, Atlanta, Georgia, 30354. And that happened prior to this incident. That happened, I believe, at 2:30 a.m. Well, it's all the same. They're all carried on the same indictment. But the incident that I described in my facts, I only described the senior complex.
Okay, so that's in Hapeville, 845 North Central Avenue, 30354 is in Hapeville. Mr. Presley, does your mom or does your girlfriend, do either of them live in East Point?
No, sir.
Do either of them live in Hapeville?
No, sir.
All right, it'll be a special condition of your probation that you stay out of East Point and Hapeville. So when you're out, you need to not go into East Point or Hapeville. We'll modify that if you end up getting a job in one of those two places, but otherwise you stay out of Hapeville and you stay out of East Point. That will address Ms. Hall's concerns. What did you want to add about restitution, Ms. Hall?
Well, it's more of a clarity question. I just want to make sure. So the victims' information I have gathered so far, along with Ms. Rolak, they are, like you indicated, they're glass repairs for most. The deductibles, they did not reach the deductible. So we have amounts from $150 to $300, most of which they couldn't locate the receipts because they allowed some shade tree mechanic to change the windows, I believe. But then there are two that did go through their insurance companies. I have the breakdowns. I just gave you the total, which is one deductible was $1,895 because it was a BMW, and another deductible was $770. I want to know if are we needing receipts on the 3 additional victims that I have to locate, or are we asking for receipts for every single one? Because I know now that I don't have receipts for quite a few because they don't have them.
So what I'm going to ask you to do is talk with Mr. Franklin. It sounds like he's being reasonable about this, and low dollar amounts. If someone says, look, my rear passenger window was busted out and I spent $50 to get it fixed, I would hope Mr. Franklin's not going to fuss about that. But if someone does say it was almost $1,900, I don't drive cars like that. That's a huge deductible. So why don't the two of you talk through it? And if there's a disagreement, we can revisit it. But my hope would be that you two could resolve this such that there is a overall dollar amount that would have to be broken out in the final disposition, because probation has to key off that. So $57 to Fred Smith, $91 to Janice Gordon, whoever these people are. And it sounds like you have that level of detail, but in the next few days, you need to talk to Mr. Franklin about that while he's getting the folks at BHTC to get an email to Ms. Nelson saying, this is Mr. Presley's status. And then we can work, if the answer is yes, we're taking him, then I can lean on BHTC to connect with Mr. Presley about housing, because they don't need to waste their time finding him housing if he's got a place that their investigators say is a safe place for him to be. Ms. Rolak, did you have anything from the victim witness side in this case?
No, Judge. Most of the victims were just concerned about their the payments, the restitution for
Okay,
the
well, it
repairs that
sounds-
they did on their cars.
Okay, well, it sounds like Ms. Hall and you have that covered. So I think I've explained what the sentence would be. It is, as written, less severe than what the state asked for, and it's effectively what you asked for, Mr. Franklin. But in case you think it's somehow more severe than what you asked for, do you have any concerns, or do you think you and Mr. Presley need to talk about whether he's going to accept that sentence?
I don't have any concerns, but I'll leave it up to Mr. Presley.
Okay. Mr. Presley, you understand the sentence? If, assuming you get into BHTC, they're going to come get you as soon as the next orientation occurs. And then you're on 10 years probation, but part of that probation will be the time that you are in BHTC. Do you understand? Yes?
Yes, sir.
Okay. You okay with that?
Yes, sir.
All right. The last two things I've got is one, I'm going to have to print out your indictment. So you'll be proceeding on a copy of the indictment. Any objection to that, Mr. Franklin?
No objection.
And then I will need to sign for you, Mr. Presley. If you're here in court, you'd actually be signing the indictment saying I plead guilty. Do you authorize me to sign on your behalf?
Yes, sir.
Mr. Franklin?
Yes.
And Ms. Hall?
Yes, Your Honor.
Okay, so I'll sign the indictment. The final disposition will hold until we hear about BHTC and the restitution piece. If BHTC says we're ready and we could get Mr. Presley on Monday, I'll sign it anyway, and I may just enter an amended final disposition with a more complete entry about restitution. I don't want Mr. Presley to miss the next cycle of orientation if he gets into BHTC, if we're still waiting on the restitution piece. I think that's everything. Ms. Hall, anything else in the matter?
Nothing else from the state, Your Honor.
Mr. Franklin?
Nothing, Judge.
Ms. Crawford, do you need me to move Mr. Presley and Mr. Franklin into a room with you?
Yes, Judge.
Okay. Now, Mr. Presley will not be reporting to probation if he gets into BHTC. He'll be reporting to BHTC. Is that correct?
That is correct, Judge. I just need to get an address and a contact person for him.
Okay. I'll do that. I think that completes the calendar. Mr. Franklin, do you have any objection if I move Mr. Church into that room as well, just so he can see what you guys talk about?
No objection. One thing I do want to add, Mr. Presley's mom just texted me. She's watching on YouTube. She did say that he can come home. So
great.
That was a concern she wanted me to tell you.
More power to YouTube. That will be an important discussion for Mr. Presley to have with BHTC. Assuming we get the green light from them, I'll let them know that Mr. Presley may have housing.
Thank you.
All right, and your mom, this just to be real clear, she does not live in East Point or Hapeville, right?
Yes, sir.
Okay, but she lives in Metro Atlanta? Mr. Presley?
Somewhere about Old National.
Okay, how would you get to BHTC?
Bus? Uber.
Bus? Okay. All right. Well, let's try to make this work. Thank you, Mr. Forte. I'll see everyone in, unfortunately, only 41 minutes. So it's a short lunch. I think this afternoon calendar is shorter, but I want to say this. This was a phenomenal calendar. We made a lot of progress with cases where we were able to move folks along, and that's good stuff. So thank you for putting in the effort you did. I will move Ms. Crawford, Mr. Franklin, Mr. Church, and Mr. Presley into a breakout room. Thank you, everyone from the sheriff's side for making this possible. Appreciate it. We'll be back on at 1.
Bye, everybody.
Breakout room.
Oh, I'm with it.
Judge, I have just something to talk to you, just 3 seconds before you sign off.
Okay, let's get these folks in. Excellent. Yes, ma'am.
Okay, you realize the calendar that we have at 1 o'clock is our first like published calendar. So it's gonna be a little bit different.
Yeah, I was gonna ask you what's it all about? So this is the one where we got the special note. Hold on one second.